in the country. So we cannot have the line 2 saying possible standard in professional there, so that we can be consistent. Yes, Majority Leader.
That is so, Mr. Speaker. Mr. Speaker, based on the discussions that we had yesterday, it is my candid view, and I hope colleagues will agree with me, that even the name of the council has to change, because it is not a council responsible for legal education broadly. It is a council responsible for professional legal education. And so there would be the need for us to go back to clause 1 and prefer some amendment to clause 1.1, which, says there is established by this act the Council for Legal Education and Training as a body corporate. We should now call it Council for Professional Legal Education and Training. Mr. Speaker, I urge on colleagues so that we can have this amendment.
So if that agreement has been agreed upon, why are they going to give accreditation? By the law. Yes, let me hear from Honorable Animedu.
Mr. Speaker, I support the amendment that is proposed by the Majority Leader. Indeed, at the meeting yesterday, we agreed, the House that met, together with the sponsor of the bill, the Honorable Attorney General, that we should go by the professional legal education. So, Mr. Speaker, I want to talk about
what happened to clause 23 of the bill.
Mr. Speaker, we are not there yet, but I haven't looked at it. When we get there, we'll cross the river.
Okay, it started from
we
clause,
said was that everywhere
from
that we have the legal education, we have
clause
to make
22.
It.
You see, in making this particular law, we have to consider the totality of the bill. That's why you must read the bill as a whole. So having read the bill as a whole, I know clause 22, clause 23, and 24 is talking about accreditation under the marginal note, accreditation of universities to offer or provide law practice training. And clause 22 is saying that the council shall, in collaboration with the Ghana Tertiary Education Commission, set standard for the accreditation of universities to offer or provide law practice training. Now, it has sub-clauses. If you go to clause 23, it's talking about requirement to obtain accreditation. You go to clause 24, it's talking about application for accreditation. So if the council is not responsible, as we are talking about, then it means that we have to do something about the distance, because so long as the council is going to give an accreditation together with the GTEC to run the training to enable the people write the bar exams, then the council cannot only be responsible for professional. Yes,
Mr. Speaker, the council will be responsible for professional training. But at the meeting, we had agreed that what would be happening at the universities are the basis, the preliminary courses for people to take aiming at the professional legal education. So they may start, the universities, they could give accreditation, but it is still professional legal training that we are aiming at.
So if the argument you are making is something that we should go by, then at LLB level, the council has no business. So why would they be giving accreditation? where would they be given accreditation? Then we have to even look at the long title, because the long title is a legal education. Yes, so what was the discussion at that committee with regard to clause 22, 23, and 24?
Mr. Speaker, the structure doesn't change. The problem that came up was we consistently referred to university. Now, Ghana School of Law came yesterday and said, well, we are not a university, but we are also involved in providing training for professional legal education. So you will have to remove the word university there and replace it with providers of professional legal education. Then we will go to the interpretation section to define providers of professional legal education. There we will now prefer an interpretation that captures universities and the Ghana School of Law. Otherwise, as it is now,
yes, I understand. But
so that's the first phase.
That's a different argument.
Then the second phase of the issues that you have raised is that the responsibility to accredit universities who will be playing a role in the provision of professional legal education now as providers of a service. That responsibility is generally the responsibility of GTEC. But for quality assurance, the council is going to collaborate with GTEC to set the standards related to LLB degrees that universities are offering, with the view that the graduates will be involved in writing the examination that will enable you to be called to the bar. So if a university is just offering its LLB degree and it doesn't care if you will qualify to write the bar exam, it doesn't need to come for accreditation. But for the universities that intend that their products should be among those who will write the LLB, the bar exams, those ones, the council is interested in the standards there. And that is why the council, with National Accreditation Board or Authority Commission, will have to accredit those universities. So the accreditation function will remain as a collaborative work between the council and
leader. Let's get it clear.
Yes.
If clause 1 with the amendment proposed should read, the object of the council is to regulate professional legal education in the country to ensure the promotion and maintenance of the highest possible standard in professional legal education. The question, therefore, is what is taking part at the universities? Is it a professional legal education?
It is the foundation. It's the foundation that you build on. And indeed, Mr. Speaker, one issue that came up strongly yesterday was a commitment to reduce the number of years. And so we spent a long time yesterday arguing about parts of the professional course that could be taught at the LLB level so that it will enable us to shorten the number of years at the law school. So, for instance, yesterday we argued that interpretation, which we do at, law school as part of the professional program, can be done as an LLB course because in tort you do some part of interpretation. In contract you do interpretation. In constitutional law you do constitutional interpretation. So you can build interpretation into your LLB program so that you can reduce the length of time. Same way with taxation and other courses, land law and etc., property, even company law. The argument was that the substantive company law can be taught as part of the LLB course, and then when you now come to law school, you'll be taught the practice, taking minutes and etc., and then drafting and etc. So that way we will be able to shorten the time frame in the law school and achieve the objective of having the course completed in 4 years. So we recognize the LLB degree for the purposes of writing the bar exams as part of professional legal education.
So what then is the difference between professional law education and legal education? Professional legal education and then legal education.
Yes, so Mr. Speaker, the difference is when you are pursuing LLM is legal education. When you are pursuing PhD is legal education. Yes, LLB is legal education. Legal education is not okay. But if it is to enable you write the bar exams, is that okay? Then the Professional Legal Education Council becomes interested in that degree. Let's say you go to Malta. You go to Malta to go and do your LLB. If your LLB at Malta is not accredited by the Professional Legal Education, it doesn't entitle you automatically to come and write our bar exams. For you to become entitled to write our bar exams, as a graduate, an LLB graduate, you must have pursued that course in a university accredited by the council. Are you getting it? Accredited by the council. That's the whole objective.
Yes, let me hear from Honorable Ranking Member. Then I'll come to the
I may want to add to what the Majority Leader has said. And I'm giving an example. Mr. Speaker, I was a foundation lecturer at KNUST. When we started the LLB course, the idea was that the students, graduates, would do 1 year at the law school. In fact, that was the thought. Therefore, subjects like company law, law of evidence, civil procedure, and other things were introduced. It's unfortunate that the Attorney General is not in the House. As the sponsor of the bill, he had even proposed that after the legal training, you go to the law school for the professional. You're going to do purely the criminal procedure, civil procedure, and probably he suggested about 4 subjects. He suggested the law of immovable property, as was taught by Lodo and whatnot. So he was saying that we could do 4 subjects.
Lodo teaches conveyancing and drafting.
Conveyancing and drafting. That's what I mean by the law of immovable property.
Yes.
Right. Mr. Speaker, so in course of time, because the Ghana School of Law and the University of Ghana did not synchronize with the thought of KNUST, they had to give up the idea. And in fact, now, there are people that do, for instance, company law, do the law of evidence at the LLB level, and they only go to the professional level, and that is repeated. But Mr. Speaker, the professional level, as we have now, we say that go do the professional level at the Ghana School of Law. Now we're giving to the universities. But we're saying that the legal training, the basic, before you could write the bar exams, you must have these trainings. You should go through the LLB procedure, and that is basic to be graduate or be admitted to write the Ghana National Bar exams.
Members, maybe my detailed reading of the bill is what is causing the problem. Because if you look at clause 62 it talks about law practice training. The law practice training says a person who holds a Bachelor of Law degree shall undergo law practice training in order to qualify to sit the National Bar Examination. So, irrespective of your LLB, by this clause 62, you have to do the law practice training to satisfy these requirements in writing the National Bar exam. So why is the council interested in giving accreditation? You see, we need to take all these things on board in coming to the understanding of clause 2. Because my understanding is that go and have your legal education. Once you qualify under clause 62, then you can write your bar exams. Yes, let me hear Honorable Buama.
Speaker, thank you very much. And it's good at this very beginning. We need to situate the import of this bill and what we seek to achieve. The mic is on. Okay. Mr. Speaker, the difficulty the amendment being proposed at both clause 1 and 2 is going to cause, importantly, is the definition we're giving to professional legal education. Because per the explanation leader was trying to help us with, LLB programs being run across all universities may not necessarily get accreditation for them to get people qualified to write the entrance exams or the bar examination. Meaning that this bill is seeking not to regulate the LLB, because if you are regulating LLB per this bill, then it means that from the LLB, you should have automaticity in doing the law practice and then going to write the exam. But the import of the bill is saying that beyond the LLB, this council will give further accreditation to some specific universities, institutions. So once you create the second layer, that second layer becomes now the premise upon which preparation for professional legal education is being targeted. So we should be very careful, else what we should be looking at, reading the bill as a whole, is to ensure that the council then regulates the LLB, and all the accredited LLB institutions become automatic institutions that can train people for the practice. But once you break these two, then the difficulty will be that the LLB doesn't become a mechanism for professional legal education based upon which this act is being targeted. So reading clause 1 and clause 2, I believe that we should be guided by where Speaker is coming from, which I also believe that this particular provision will lead to some absurdity. Thank you, Speaker.
Yeah, Dr.
Thank you, Right Honorable Speaker.
Yes.
For
Dr. Sosu.
Yeah, thank you very much, Right Honorable Speaker. Mr. Speaker, I think that.
Well, inform the clerks at table. They say they don't have it in the record.
Oh, Mr. Speaker, I would use the platform and following the precedent of the venerable leader Osahi to inform the clerk at table that this week I was conferred, or I was awarded PhD in law. And so the clerk at table can amend their records to reflect that. Thank you very much, Mr. Speaker.
Yes.
Mr. Speaker, I think that the purpose of this bill is to regulate professional legal education. It is important for us to distinguish between LLB programs and professional legal education. LLB programs are already programs that are accredited by GTEC. It's part of academic discipline that is accredited by GTEC. What the council seeks to do is to regulate professional legal education, that when you finish your LLB, the processes towards becoming a barrister and a solicitor, that is what the council seeks to regulate. And the reason why the council may be interested in what happens at the various universities is just to ensure that students that are being produced at universities are of high quality to be able to take those professional legal education. But beyond that one, that is the domain of the GTEC. Mr. Speaker, what that means is that the council, with its accreditation powers, is going to monitor the LLB programs happening in the various universities, so that it's not automatic that a university or an institution will be accredited to run a professional legal education. The council is going to look at their facilities, what their staffing, their cost structure, before the council will then grant accreditation for them to run the professional legal education, which currently is run by only the Ghana School of Law. So the purpose is to break that monopoly, give access to other universities that have the facility and the capacity to run professional legal education. And so I believe that the amendment proposed the amendment proposed by the bill is in its place. And in fact, the rendition is accurate. And Mr. Speaker, if you may put the question for us to move forward.
Yes, we agreed on the rendition, but it is the other provisions in the bill that is making it a bit clumsy as to whether they are in charge of legal education or they are only restricted to professional legal education. And we must be very careful to avoid conflict of laws. GTEC is established by law to give accreditation to universities. Now, if we make this particular law to say that GTEC must give that accreditation for LLB together with the council, what happens if there is a conflict? You see, that is one leg. Now, the second leg is that if you look at the bill, even where you are accredited to read the LLB by the council, and you have finished LLB as the council, you are not qualified to do the bar exams. You understand? You must be trained by an institution accredited to do the law practice training. That's why I'm of the view that if you are going to restrict it to a professional legal education, then the accreditation should be limited to the institutions that will be training in the law practice, so that from there you go to write your bar exams. So to say that the universities at the LLB level must be accredited by the GTEC together with the council is where the complexity is coming from. But let's put the question. When we get there, we'll do the best to make sure that we don't have internal conflicts in the same laws that we are making. So, all members, taking into consideration the proposed amendment by the chairman and the Honorable Kingsley Nyako and the majority leader, the new rendition that I'll be putting the question on reads: the object of the council is to regulate professional legal education in the country to ensure the promotion and maintenance of the highest possible standard in professional legal education. Honourable members, I'll put a question. All those in favor of the proposed amendment say aye. Aye. Those against say no. Honourable members, the proposed amendment to clause 2 are carried. Then I'll put a question on the entire clause 2 as amended. All those in favor of clause 2 as amended, standing part of the bill, say aye. Aye. Those against say no. The ayes have it. Clause 2 as variously amended is ordered to stand part of the bill. Clause 3
Functions of the Council.
Mr. Speaker,
Yes, Chairman, hold on. Let me hear Honorable Medu.
Mr. Speaker, the Majority Leader moved for an amendment at clause 1. And what we have done at clause 2, it must be consequential. So if we could consider that before we proceed, Mr. Speaker. Thank you.
There may be consequential directions. It will even affect the long title and then the eventual title of the bill. So that one, let's leave it for now, so that when we come to consider the long title of the bill, we'll give those consequential directives. Clause 3, Chairman of the Committee.
Mr. Speaker, Clause 3, amendment proposed, paragraph A, delete and insert the following. A, accredit universities to provide professional legal education and training in the country in accordance with paragraph B of subsection 3 of section 8 of the Education Regulatory Bodies Act 2020, Act 1023.
Honourable members, the proposed amendment is for the consideration of the House. Yes, Honourable Professor Kingsley Nyako.
Mr. Speaker, yes, so at the Economic Committee, I suggested that instead of universities, we should make it tertiary education institutions, because the faculties or institutions that run law programs, they are not all universities. Some are university colleges, some are colleges. So if you make it universities, then it excludes those other institutions that run law programs. But leader advised that it will be part of the interpretation moving forward. Because if you read at 1023 as captured, it talks about tertiary education institutions and not universities. You wouldn't see universities in the bill. So I'm suggesting that
the Act 1023 talks about tertiary education
institutions, not universities. So if we could capture this as part of the interpretation for universities to mean, then it should be accredited tertiary education institutions instead of universities. And there should be consequential amendment to anywhere we find universities. Thank you.
Yes, the proposed amendment is for the consideration of the House.
Speaker, I have another proposal to the amendment. Instead of tertiary institutions, it should be, instead of tertiary educational institutions, it should just be accredited institutions. Speaker, because we are seeking to maintain the Ghana School of Law as it is, to continue to offer its foundational, to build on its foundational or foremost place in offering legal education. There are other private entities that are interested in establishing schools that will be accredited to offer professional legal training. So it should simply be accredited institutions, whether tertiary, whether found at the tertiary level or specially established for this purpose. It is. Yes, so I'm saying it should be accredited institutions, not accredited tertiary educational institutions. No, it should just be accredited institutions, not universities. Yes.
Yes, Honorable Wama.
Speaker, thank you very much. I just want to draw my senior chief whip's attention to the B that is being suggested. Already, it's reading, shall in collaboration with the Ghana Tertiary Education Commission set the standards for the accreditation. So there's already
that was a law program.
Of a law program in tertiary educational institutions. So you amend that, yes. So we want
Yes.
You want us to add in accredited tertiary.
Accredited institutions.
Yes, let me hear from the leader of government business.
Mr. Speaker, let me say, I'm holding the paper presented by the Court of Appeal judges and the deans and the directors of the law school. And their proposal was that replace the word universities in the bill with professional legal training providers. This may be the Ghana School of Law or any other institution accredited to run professional legal training programs at the universities. But if you don't replace that word and you keep using universities, because this will now be the main legislation governing professional legal education, law school will be totally eliminated because it is not a university. So, consistent with that...
Leader,
Yeah.
we got that point.
Yeah.
Now, who give accreditation to the Ghana Law School?
The council
Is
will
it-
now do that. The council.
Is it GTech?
No, the council that we've just created, the Professional Legal Education Council,
Yes.
they will now take up that job.
Yes.
Yeah, in collaboration with GTech.
So, the categories are now 3
Yeah.
per this bill. One is the LLB, which is offered at the university level. 2 is a professional practice trainee. And then the third layer is the bar exams. And when you pass, you then become a lawyer. That is the understanding that I am getting. So, which level is accreditation being required? Is it required at the level of LLB? Is it required at the level of the practice training institution? So, if it is limited to the practice training institution, where are we bringing the universities? Unless the universities have decided to offer the practice training, then they will not be accredited. You understand? And in that case, for the practice training, GTech does not come in. It is the council that comes in.
Speaker, if you may hear me. Speaker, the essence of all this reform is to offload the mandate of Ghana School of Law as it is to the faculties because of issues of space. Now, we are setting up this legislation to empower the faculties to be able to offer the professional training. Now, in doing so, there will be standards. So those standards will be set by the council, in addition to the standards necessary for accreditation set by GTech. That is why we are seeking for a collaboration between GTech and the council in offering the accreditation to the faculties or the law schools, as they want them to be called now, that are prepared or will be willing to take advantage of this new reform. So to be able to meet the standards set by the Ghana School of Law, the checklist provided by the council will have to be met by all the faculties that will be interested. So if you offer the program to your product, possessing your LLB, to go through the professional training, then you'll be at par with what the law school provides presently. Then all of you will prepare to write the national bar exam, which is offered only by the council.
Yes, so that is why I'm saying that if
Yes.
care is not taken,
Yes.
you may get GTech to also be giving accreditation for the professional practice training.
At all, Mr. Speaker.
So my understanding is that
Yes.
whatever is at the university level,
Yes.
let's leave it for GTech. You understand?
Mr. Speaker.
Then when it comes to the professional training and practice, any university, any tertiary education institution that wants to offer a professional training, a professional practice training, must come to the council for accreditation.
Mr. Speaker, that is exactly what it is.
No, but we are saying that the council must accredit LLB level at the university
the
level
council
with
is
GTech.
not. No. the council is not accrediting the faculty to run LLBs. The council is saying that to be accredited to offer the professional training, there are additional set standards that you must meet.
You see, I made reference to clause 22, 23, and 24.
Mr. Speaker.
And
Mr. Speaker.
yes,
Mr.
just
Speaker.
a minute.
Mr. Speaker, please.
Yes.
Please, Mr. Speaker.
Yes.
Mr. Speaker. Listen. Clause 3A says, accredit universities to provide professional legal education and training in the country in accordance with paragraph B of subsection 3 of section 8 of the Education Regulatory Bodies Act. So under that act, it is the GTEC that does it. So the accreditation is to be done according to the GTEC Act. That's the Education Regulatory Bodies Act, not this act. Now when you go to 22 is focusing on the setting of the standards for the accreditation. Clause 22 says that the council shall, in collaboration with the Ghana Tertiary Education Commission, set standards for the accreditation of universities to offer or provide law training, law practice training. So it is the standard setting that it is to collaborate. Oh no, read it. It's there. Yes. No, let me read it. It says, the council shall, in collaboration with the Ghana Tertiary Education Commission, set standards. Not actually carry out the accreditation itself, but set standards for the accreditation of universities to offer or provide law practice training. And then 3A says, accredit the universities to provide professional legal education and training in the country in accordance with Education Regulatory Bodies Act. So when it comes to the standards, it is the council and GTEC. They have to work together to set the standards. When it comes to the accreditation, it is done according to the GTEC Act. That's how I read this. That's how I read this.
Honourable Majority Leader, let's get it clear. My understanding is that for the professional law practice, the standard, the accreditation, is an exclusive preserve for the council.
Let me explain.
The professional training and
let
practice.
Me explain. You see, now that we are going to permit the universities to also provide the training program, GTEC says the university is our preserve. The university is our preserve. It's not your Ghana School of Law. The university is our preserve. So we regulate the degrees. Now, if you come and say that the university should run a professional law course training program, we will still accredit that one. Then we are saying that the council would work with you, set the standards for you to accredit the universities to run the professional legal education program. The Attorney General is here. If I'm not presenting it properly,
Attorney General, help us. The problem is caused by clause 2. First, the title of the bill, the long and short title said legal education. Okay. Legal education goes beyond a professional training because there is a degree aspect of it. So the issue is whether it should be the legal training or professional legal training. Now, when we came to clause 2, there was a proposed amendment, and the new rendition for clause 2 is that the object of the council is to regulate professional legal education in the country to ensure the promotion and maintenance of the highest possible standard in professional legal education. So the House has agreed on this rendition. So the question therefore is, what then is the difference between legal education and the professional legal education?
Mr. Speaker, given where you and I come from, how we became lawyers,
Yes.
I don't expect that we should be asking this question, because legal education definitely comprises two tiers. Tier 1 is the LLB program, the Bachelor of Laws program, which is offered by universities accredited to run bachelor's programs generally. And if they have a faculty of law or a school of law, that faculty or school will, train people, educate people and issue them with degrees for the bachelors of law. That's tier 1. Tier 2 is what you and I went through when we moved from the Faculty of Law, University of Ghana, and went to the Ghana School of Law, otherwise known as Makola,
Yes.
where we did our professional training. That is tier 2. Now, it is tier 2 that created the problem. Tier 2 is where the problem of legal education, was, and that is what animated our desire to reform legal education. So it is tier 2, that is the professional aspect, that this bill is seeking to regulate. Now, the thinking within government, the logic of the bill was that if we regulate tier 2, and then we don't regulate tier 1, and tier 1 produces chaff, the chaff will move to tier 2, and the quality of legal education standards will fall. So we made an attempt to link tier 1 to tier 2 by saying, look, if the Council for Legal Education and Training has to regulate tier 2, then it has to have a role in how the standards of tier 1 are set. So we decided that they should do so in collaboration with GTEC. All right. Now, GTEC has given us an input where they are saying that, look, tier 1 is our territory. We will deal with the universities when it comes to accreditation for running the Bachelor of Laws programs. And so leave that to us, but concentrate only on tier 2, which is a professional legal education. Now, the thinking is that instead of us having the monopoly of the Ghana School of Law, where people are writing entrance exams and you have a backlog of 6,000 students with LLBs who cannot get in, we will now decentralize tier 2 and allow the universities to get accreditation not from GTEC, but from the Council for Legal Education and Training, to now give them, in collaboration with GTEC, for them to do the tier 2, that is the professional legal training. All right, that is the law practice course will be run by the universities, and the accreditation will be done by the Council for Legal Education and Training. Because that council, as you rightly pointed out in clause 2, will be in charge of professional legal education. So that is the linkage. And we want to focus more.
So why didn't you bring the bill as professional legal education bill, but you are saying legal education bill? That's what is causing the confusion.
Mr. Speaker, the thinking within government was broadly to overhaul the legal education regime in the country. That was the thinking within government. But in collaboration with some of the stakeholders, or in consultation with some of the stakeholders, for instance, yesterday, leader presided over a meeting where the ranking member on Constitution and Legal Affairs, the Honorable member for the Honorable Kwame Imedu, my own classmate, the Honorable Imedu, was there. And at that meeting, the law teachers, the lecturers of the Ghana School of Law, all of them came together and they made an input. They made substantial input. And I told them I am an open-minded person when it comes to how we reform legal education. So I listened to them. And one of their concerns was that the scope of the bill should not extend to the running of the LLB programs, and that we should narrowly, refine the scope of the bill to deal with professional legal education, something that GTEC has also pointed out. And then leader agreed that that is what, the route that we should be traveling on, and that is how come that we are amending it to read the professional legal education bill, in order to align with the thinking of some of the key stakeholders.
You would agree with me that where I'm coming from and where you are also coming from, there is tier 1 and tier 2. So the focus of this particular bill should be on tier 2 rather than tier 1.
Mr. Speaker, in the past, when it came to regulating professional legal education, the focus was on tier 2. Minister, the focus was on tier 2. But because of the reforms, there is some apprehension about standards. And the approach to dealing with the problem of standards is that we'll go back to tier 1 and be interested in what happens in tier 1. So if you look at the bill itself, you'll find out that the bill substantially regulates the LLB degree. If you look at this bill, from clauses 15, from clauses 15, no, not 15. There are clauses that provide for 22, the accreditation. You find out that from those clauses onwards, we delve into the LLB degree, the courses that should be run. Is that okay? We delve into the accreditation and the standards in terms of the personnel that should be teaching in the university. We delve into even the library and the IT infrastructure, all at the LLB level, because people are apprehensive that if you just say that people should go and then write a bar exam, you may end up churning out substandard lawyers for us. So for that quality assurance, we've gone back and we're interested in the foundation, which is the first degree, to make sure that by the time that a university is accredited to even offer the first degree, you have met all the criteria, and then we're even obliging the council to institute an annual inspection of the universities that are offering the program, just to be sure that even the LLB degree, the standards there are well maintained. Yes. So that the product can then go and do the professional training program and then can go and write the main examinations. Yes. So, Mr. Speaker, yes, the academic law degree is there, then the professional law degree is there.
Yes.
But by this new regulation, we have co-opted the first degree program into the professional training. And we're even advocating that because of what we are doing, we should move some of the professional training program back into the LLB program so that we can shorten the professional period from 2 to 1.
If that is the case, I am comfortable with the use of the language legal education instead of limiting it to professional legal education because of where I'm coming from. You see, because of where I'm coming from, you see, we give the law, Parliament passed the law to give the power to GTEC to give accreditation. So if Parliament today is taking that particular power to give accreditation regarding legal education to the council, that is the law Parliament is passing. That's the law Parliament is passing. AG, are you getting the point? So on one breath, we want it to be professional legal education. In another breath, we want it to be legal education. That is why we are saying that, are we talking about professional legal education or we are talking about legal education? So, Honorable John Dako.
I think that, Leader, I agree completely with the Speaker on this, 100%, because your proposal to bring the LLB run programs under the legal education program is a legal education reform. So if you're putting all of that together, we cannot call it only professional legal education. It's a legal education reform we are doing. And so if you are going to, by your example, we cannot limit the name. I think that the name as it is right now, legal education bill, should stand. And it will cover everything we are talking about. Because when we change the name, it means that we are dealing with only the second tier as we've been talking about. But from what we are saying, we are dealing with both first tier and second tier, and that's legal education reform. So that let me agree completely with the Speaker.
Honorable Sosu.
Thank you, Right Honorable Speaker. Mr. Speaker, I think that we probably when you look at the engagements that we've had with the various stakeholders, Mr. Speaker, the understanding that I have is that we are regulating professional legal education. There is no two ways about that. The essence of this bill is that traditionally, we have the universities running LLB programs accredited by GTEC, and the Ghana School of Law runs the professional legal education. What we are doing with this bill is to take part of Ghana School of Law's mandate and give it to various universities that have the appropriate infrastructure to run the professional legal education, period. Mr. Speaker, we cannot use this bill to amend the lack of quality in training of LLB in universities. That's not what we are doing here. We can't say that because the council is interested in how the foundational courses are done, the bill is stretching its arms into GTEC's mandate. I believe that the essence of this bill is professional legal education. And Mr. Speaker, all the provisions that were referred to, when you go to provision from 22, 24, 23, it relates to the universities that seek to run the professional legal education, period. It has nothing to do with LLB and all those things, Mr. Speaker. That's my respectful view, Mr. Speaker. That's what it is.
Thank you very much. Honourable members, I've been hearing from lawyers. I intend to hear from the doctors also. Honourable Dr. Abeyu, you have the floor.
Thank you very much, Mr. Speaker. Mr. Speaker, I thank you for the opportunity to contribute to this. I think there is an example in medical education that I think can help what we are discussing, and I just want to profess that opinion. Mm-hmm. In the medical education, if you look at it technically, we also have a basic sciences component of our education, and then the clinical component, which is analogous to your professional law program. The basic sciences is done by the universities, regulated by GTEC, but the council, Medical and Dental Council, has interest in it. So there is a complementary regulation. So if you need to start a medical program, a medical degree program, for your first 4 years where you get your BSc in medical science or human biology, you need to get accreditation from GTEC, but at that same time, you have to get the Medical and Dental Council to see. But you go to GTEC first, and the Medical and Dental Council does a complementary regulation because it's a professional program. You cannot sit and look only at the top, because at that time, if the quality of material coming to you is bad, you can't correct it within 2 years or 3 years. So that complementary regulation is important. So I think that we should take the opportunity of this new bill to make sure that GTech plays its role. Then the general Council for Legal Education also does complementary regulation at the basic level. Then when they come to the professional, then it's completely the...
Yeah, so in the Medical and Dental Council,
Yes.
what is the object? Is the object limited to professional?
It is to professional. Okay, I don't know whether we are saying that you can have professional and non-professional medics. We see the profession, the entire profession, the entire medical field as a profession. So right from your entry, you have started a professional track. So the goal is to go through the process. Of course, there are people who don't finish.
So it is in all medical and dental education.
Yes.
That is why people are proposing here that it should remain legal education, but not professional legal education.
So, Mr. Speaker, if they want to suggest that they are, I don't know how. I mean, I'm an educationist myself, and I don't know why I'll be interested in the terminal end and not be interested in what is fed to the terminal end. Because we all know that when the foundation is wrong, it takes a lot of energy to attempt to correct.
That is why members are trying to agree.
Yes.
With the law that came to the House.
Yes.
That it should be the object of the council is to regulate legal education in the country to ensure the promotion and maintenance of the highest possible standard in legal education. But there is an introduction to limit it to professional legal education. Yes, AG.
Yes, Right Honorable Speaker. All my former students who are standing up, I will revoke their degrees. Including the honorable member for Damango. Mr. Speaker, on a more serious note, what the medical doctor has told us is precisely what we are concerned with. All right? But legal education is a comprehensive concept. It includes the LLB, the LLMs, all right, and then the PhDs. And this bill is not seeking to regulate all that spectrum of degrees. We are not going to cover all of that. I do agree that it's a question of nomenclature and not substance, because the bill itself seeks to deal with aspects of legal education that it has defined very clearly. But as the medical doctor rightly pointed out, if you are not concerned with the base, what will then happen is that the base might produce chaff that will come up to the top. But we don't want to take over, the functions of GTech as far as the base is concerned. So we will, in the words of the medical doctor, do complementary work when it comes to the LLB. Okay? But when it comes to the professional aspects, the Council for Legal Education and Training will comprehensively regulate and accredit universities. So, for instance, if there's a university that is offering an LLB program, but we know that they do not have the infrastructure, they have neither the infrastructure nor the personnel to be able to run the program, the Council for Legal Education and Training will not allow that university to run the professional program. That is the essence of what we are doing here. So I do not think, Mr. Speaker, that qualifying it with professional legal education does any harm to the form and substance of the bill. I think that from the from the advice that we got from, or let me say, the input that we got from the law teachers and the law lecturers, qualifying it with professional pinpoints the problem that the bill is seeking to solve. But no harm is going to be done if we leave it as legal education bill and not the professional legal education. So we'll leave it to the House.
Members, let me take two more If it still creates problem, we'll defer it. So I want to give the floor to Honorable Abu.
Thank you very much.
But take into consideration the caution by the Attorney General.
Mr. Speaker, I'm fully cautioned. Mr. Speaker, I think you've been trying to simplify the discussion. And the objectives or the goals the government seeks to achieve are all welcomed. The only confusion, Mr. Speaker, is the mandate to regulate academic legal education and professional law or legal training. That's because, and I see that my master is engaged with the medical doctor. But before the Attorney General came into the chamber, the majority leader actually indicated that they seek to fuse LLB into professional legal education or professional legal training or professional law training. And he even gave the examples of interpretation can be taught at LLB, company law, aspects of company law can be taught at LLB. Mr. Speaker, that is where we have a problem. And Mr. Speaker, my respectful view is that academic legal education, LLB, LLM, or PhD in law, that should be the preserve of GTech and tertiary education. If you want to proceed to acquire professional legal training to become a lawyer, Mr. Speaker, hitherto it was within the remit of the General Legal Council, which is what the government or parliament is seeking to change, to have this council rather regulate it, and also break the monopoly of Makola and allow other institutions who want to engage in professional legal education to so do. That should be within the preserve of the council. But Mr. Speaker, once you begin to straddle between the remit of LLB, the council can, in conjunction with GTech, can regulate it. And that's where the confusion is. Because in this country, Mr. Speaker, basic education is regulated by the Ghana Education Service, which is kindergarten, primary school to secondary school. Tertiary education is regulated by GTech. That is what it is. Now, if you want to say you want to focus on the foundation, somebody will say to you, then start from kindergarten. Then let this council be responsible for even the work of Ghana Education Service. That would be overly simplistic. So, Mr. Speaker, what I'm saying is, to conclude, the council should be responsible for professional legal training. GTech should be responsible for tertiary academic legal education. There are people who want to do LLB, they don't want to proceed to do professional course, they want to continue to go and do LLM or do a PhD. That falls within the remit of academic, that's GTech. But if you want to veer into professional legal training, then this council will come to play. And if a university wants to set a school to engage in professional legal training, they will then require accreditation from this council. And that simplifies the matter. Mr. Speaker, so let me conclude by respectfully suggesting to my master, the Attorney General, that they should withdraw the bill. Here he says that government thought through it very well. But with the suggestions we're giving to them, if they withdraw the bill and simplify it this way, it will achieve the goals they've set for themselves, and it will also ensure that there is a simplification when it comes to who
regulates what. A bill that is within the domain of Parliament should be withdrawn. Then what is your responsibility as a member of Parliament?
Mr. Speaker, either they will take your
suggestion. Are you not a lawmaker?
Mr. Speaker, I take your point. I'm guiding.
Please.
Either they will take.
You withdraw the suggestion that the bill should be withdrawn. Yes, Majority Leader.
Mr. Speaker, thank you very much.
Mr. Speaker, I think that when you participate in this debate, be sure you've looked at the entire bill and understood the structure. Mr. Speaker, when I say that we have an interest in the quality of even the LLB, it is captured in the bill. So go to clause 48. So when you go to clause 48, it says the council shall, in consultation with accredited universities, develop a comprehensive curriculum for a Bachelor of Laws degree program. Bachelor of Laws degree program. Okay? Now, 49 then delves into the content of the Bachelor of Laws degree program. That is the LLB program. Then 50 then talks about minimum requirements for Bachelor of Laws degree. Minimum requirements, which courses you must read before you are awarded a Bachelor of Laws degree. And then the bill keeps mentioning law program. Go to the interpretation section. The bill gives a definition of law program and says that law program means the Bachelor of Laws degree and law practice training. So this bill has linked the two. This bill is saying that we are carrying out a comprehensive review of legal education. We are interested in the law degree. We recognize that the law degrees are run in the universities. The universities are already accredited by GTEC. But we're interested in the component of what the university is offering, which will be passed on to us for us to churn out as lawyers. So we're not going to sit back and allow GTEC to regulate generally, because what GTEC does is regulate generally. We are going to be interested in the standards when it comes to the LLB. We are not interested in LLM. We are not interested in PhD, because even if you get 10 PhDs and you don't have the basic law degree, you will not be allowed to write the bar exams. So we're only interested in the LLB. And so we are interested in the courses that you must run there, the quality of the teachers that will teach there, the standard of marking exams, how you can appeal if you feel that the exams you have been unfairly treated, all that we are interested in it. So there must be collaboration between the council and GTEC when it comes to setting the standards there.
Yes.
That is all we are saying.
Yes.
Now, when it gets to professional legal education, again there, even though we, the council, are primarily the drivers, but because it is going to now take place in the universities and not the law school, we must again work with GTEC so that we will work with their universities and accredit their universities to run the legal training program. So both the first phase and the second phase, the work is going to be with GTEC, except where the program is going to take place at Makola, because Makola is not a university. Makola is not a university. So they even proposed yesterday to us that we should have some provisions establishing Makola also as an institution, because as it is now, they don't even have, an act establishing them as an institution. So since we're interested in regulating professional legal education comprehensively, they are proposing that we also propose some clauses that establish Makola as an institution. So we advise them to go back, work on that component, and bring us a proposal by Monday for us to look at, yes, because it won't be too late.
So, leader, that is why your proposed amendment that we should insert professional is problematic. So it means that the object of the council is to do the fuse system, both the professional and the LLB course. So why are you introducing to say that the object of the council is to regulate only professional legal education? So that is what is causing the problem. Because we are dealing with the object, and with the explanation that you have given, the object is to regulate the bachelors as well. So the object is not limited to professional degree. Yes, AG.
Mr. Speaker, you've won the debate. Mr. Speaker, with all due respect, I know you are not supposed to take part in the debate.
Yes, I'm not debating.
But I think, as I mentioned earlier, the question of substance, all right, should prevail over the form. So I think we should abandon the amendment to qualify it as professional.
Exactly.
Giving leaders, latest explanation. I think that is better we leave it as legal education bill instead of professional legal education bill. Thank you.
So, all members, do I put a question on clause 2? I think based on this explanation, we can come back to clause 2 and then take the rendition as it is minus the use of the word professional. So, honor members, then the rendition for clause 2 is the object of the council is to regulate legal education in the country to ensure the promotion and maintenance of the highest possible standard in legal education. I'll put a question. As many as are in favor say aye. Aye. Those against say no. The ayes have it. Clause 2, the new rendition is ordered to stand part of the bill. Now, let's come to clause 3 now. Clause 3.
Functions of the council.
Yes, the proposal in A is to change university to institution. And it is for the consideration of the House.
Speaker.
Yes.
What I said was tertiary education institutions. That was what I proposed, to replace universities, not institutions, unless somebody had a counter.
Yes, but we are in a deliberative stage. The proposal is that if you say tertiary institution, then the law school is not being featured here. That is why we have to refer to institution. So any institution that is accredited to offer the course will be, the accreditation will just be in accordance with the Education Regulatory Bodies Act. Yes, let me give the floor to Dr. Kabiru.
Leader. Oh, Kabiru. Oh, sorry.
Mr. Speaker, I'm tempted to go with the proposal by Professor Nyako on the sense that the Ghana School of Law, per this particular bill, is established as of law. And if you refer to clause 77, Mr. Speaker, clearly says that establishment of the Ghana School of Law and the mandate for that particular school of law is defined in this law or in this bill. So it is distinct. And in this particular bill, we are treating it as a directorate of the council. And I'm not sure if we are having in contemplation the Ghana School of Law to say that we should change it to institution that will address the issue, because the Ghana School of Law is already defined in this law and is made a directorate of the council with specialized role, including responsible for, the post-call. So, Mr. Speaker, I think that the rendition by Professor Nyako would address the issue than trying to conflict it with the mandate of the Ghana School of Law, because in this this bill, clause 77, clearly defines the Ghana School of Law and what it is supposed to do. So that is what I think, that we should not bring in the Ghana School of Law in this particular definition of tertiary institution or tertiary university. His rendition should be what we should be going by, Mr. Speaker. Thank you.
Very well. It is for the consideration of the House. Yes, Honorable Kwame Sefa, Member of Parliament for Anglong, you have the floor.
Thank you very much, Speaker. Speaker, I want some form of clarification here. Is there no way that we can have Ghana School of Law, Makola, or Ghana School of Law, Legon, or Ghana School of Law, Kumasi, or so that the same people will just be having that power to regulate all those schools, rather than trying to give power to universities to do ABC. Those at Makola should be able to have campuses if there is a need, so that we have peace. In fact, to me, there is no need to be having this back and forth. We should be able to go over this because, to me, there are a lot of bills that we have considered here. For instance, the basic education bill, where we have agreed that at the basic level, as soon as you get to the second cycle, you choose to go to TVET or you go to senior high school. Over there, there are other organs or systems that take care of that. So if we train the people at university level and they want to become a professional, what is difficult if the same Makola people can also have branches all over and take care of that? This is my candid opinion about this, so that we move forward. Else, what I would suggest is that the bill should be referred back to the Wire Committee for them to go over it and come back for us to have a peace of mind to go on. Thank you very much for the opportunity.
Honorable Buama, then
Speaker.
I'll come here and come here.
Speaker, just a small point, particularly based on what Honorable Attorney General raised, concerning even the functionality of the Ghana School of Law. If you take a look at Clause 77 and 78, Clause 77 is saying that there is established by this Act the Ghana School of Law as a directorate of the Council. And then it gives the functions of the Ghana School of Law. So it throws out and away all these issues around getting the law school to operate as an institution amongst others, because per Clause 77, 78, the law school is only the directorate of the council. And so the way things are going, I think a lot of proposals have come from various quarters, like we are being told. Unfortunately, as we know, we've not been privy to a lot of the issues that came after we met. Looking at the way discussions are going amongst others, I think we should be very careful, else we will set one amendment and then it will go and become inconsistent with other provisions. So, Speaker, I just want to draw our attention to, for example, the status of Ghana School of Law as in Clause 77, 78. Thank you.
Yes, honorable members, let's advent our mind to 78B. Offer courses, including, it's not limited to remedial courses. So the functions are clear. Yes, Honorable Dr. Sosu.
Yeah, thank you, Mr. Speaker. Mr. Speaker, I recall that when we had the engagement with the various stakeholders, one of the proposals that came, as far as the use of universities is concerned, is that it says that we should replace universities with professional legal training providers. This is what came from the eminent deans of the various faculties. That instead of, and it says that this may be the Ghana School of Law or any other institution accredited to run professional legal training programs at the universities. So, Mr. Speaker, I propose that we replace the universities with professional legal training.
So, in view
providers.
of the amendment to Clause 2, why are you still talking about professional?
Yeah.
Consequentially, it should be legal education.
So, very well, Mr. Speaker. So it will be legal training providers, Mr. Speaker.
Yes.
Yes.
AG, we want to hear you on this before we make progress.
Mr. Speaker, I think I align myself with the Honorable Dr. Sosu's proposal, which is that it should be it should be legal education providers, so that it's comprehensive enough to cover the Ghana School of Law.
Yes. And then the tertiary institutions that will also be doing the practice training. Yes?
Thank you, Mr. Speaker. Today, I've struggled to catch your eye.
Mr. Speaker, we know GTEC is in charge of the National Qualification Framework, be it from primary school or up to PhD level. And if you look at Act 1023, the Act 1023 8.3b, it talks about the relevant regulatory bodies accredit professional programs and institutions at the tertiary level. So instead of bringing in professional legal body or universities, Mr. Speaker, I'm proposing, because of what is stated at Act 1023 8.3b, we can just insert training institutions. In that case, it can cover Makola or any other institution, because this one has already been stated here, and it says in accordance. If you look at it, it says in accordance with paragraph B, subsection 3 of the Education Regulatory Bodies Act. So instead of putting universities or putting professional legal education, I am proposing that we put training institution, because that training institution has already been qualified by Act 1023, which is tertiary level education. Thank you.
So that, is it not closer to legal education providers?
Mr. Speaker, because anybody can apply for that legal education license, that is why it is better not to limit it, because that is a professional body already stated. And we are trying to move away from the professional legal education or legal education.
No,
so
this one is generally legal education providers, as suggested at the meeting.
Mr. Speaker, I think I'm proposing that we state training institutions. That is going to work. Instead of going to word legal training institution, then that will be fine. But I propose that at least training institution, this has already been defined by Act 1023 at tertiary level. So we can put legal training institution. That will be fine.
Yes, Honorable Peter Nochukoti. Honorable Peter Nochukoti, you now have the floor. Honorable Nochukoti, you now have the floor.
Thank you, Mr. Speaker. Mr. Speaker, I'm talking about the amendment as proposed. Say, if you mention just universities, and it is not defined to include other tertiary institutions like Ghana School of Law, it will create a problem. So I am of the view that we delete the universities and then insert tertiary institutions or legal tertiary institutions, whichever of them I think is better. I would prefer tertiary institutions, which will include Ghana School of Law.
Yes.
Thank you, Mr. Speaker.
So, AG, what rendition will you support? You still stick to the legal education providers?
Very, very well, Mr. Speaker. I think that broadly covers the whole spectrum of the institutions that will provide legal education.
So, honourable members, can't we use the word institution and go to the interpretation to define it? Yes, Honourable Sosu.
Thank you, Mr. Speaker. Mr. Speaker, I believe that the legal education providers can equally be defined to include universities and all the other tertiary institutions.
Yes, I'm not really too fixated. So
Yes.
whatever terminology you use here, you
So,
go
Mr.
to the
Speaker,
interpretation
yeah, Mr.
and then
Speaker.
you define it.
Yes, Mr. Speaker. Mr. Speaker, so I urge the House that we adopt what the stakeholders, when we engage them, what the rendition that
Because
they provided. which
the
is
argument
legal.
of Chair Asamoah is
Yes.
that in line with the Education Regulatory Bodies Act, the word used is institution. So in this context, we can use institution and go to the interpretation, then we
Very well,
define
Mr.
the
Speaker.
institution to include.
Yeah, Mr. Speaker, I think that rendition is not also not. It will hurt the bill.
Very well. Honourable members, I will direct the drafters that they should provide the definition of institution to be very elaborate to include all legal education providers. So the rendition will be accredit institutions to provide legal education and training in the country in accordance with paragraph B of section 3 of section 8 of the Education Regulatory Bodies Act 2020 Act 1023. Is that the sense of the House? I'll put a question. As many as are in favor of the proposed amendment to clause 3A as captured, say aye. Aye. Those against say no. Clause 3A as amended is ordered to stand part of the bill. Yes, Chairman of the committee.
Thank you very much, Mr. Speaker. Clause 3, amendment proposed, paragraph B, delete and insert the following. B, in collaboration with the Ghana Tertiary Education Commission, set the standards for the accreditation of a law program in universities. Well, yes, institutions.
So, honorable members, I want to direct that consequentially, where you see university, it should be replaced with institution. So, drafters, kindly take note. Honorable members, my suggestion is that to move a bit faster, instead of repeating the amendment proposed by the winnowing committee, then we say, as captured in the bill before us. Yes, Honorable Chair Samuel.
Thank you, Mr. Speaker. For this amendment, I believe that it's already been taken care of by A, because A is the collaboration that you are expecting to be done between GTEC and the relevant professional body, and it's being repeated here again. So I think that this clause
is completely different. A is saying that you do so in accordance with, but the B is saying in collaboration with Ghana Tertiary Commission, set the standard. You are giving accreditation in accordance with the law, what the law says you should do. But the B, you are setting standard in collaboration with GTEC, so it's not one and the same. Is it the same? You still insist? So I'll put a question on clause 3B as proposed by the chairman of the committee, taking into consideration the consequential directives to replace university with institution. All those in favor of the proposed amendment to clause 3B say aye. Aye. Those against say no. The ayes have it. Clause 3B as amended is ordered to stand part of the bill. Chairman of the committee, still clause 3.
Clause 3, amendment proposed, paragraph C, delete and insert the following as advertised on page 5.
Yes. Honourable members, the proposed amendment is for your consideration. Yes, Honourable Dr. Kabiru.
Mr. Speaker, I'm proposing further amendment to the proposed amendment by the committee in respect of clause 3I. Is that
now on clause 3C, the amendment is to use the word supervise accredited institutions to ensure continued compliance with the set standard of accreditation. So we are not at I yet.
I'm guided, Mr. Speaker. I thought for him to take the whole of clause 3. Thank you.
No, I'll put a question on clause 3C. As many as are in favor of the amendment proposed by the chairman of the committee as captured by the winnowing committee say aye. Aye. Those against say no. The ayes have it. the proposed amendment is ordered to stand part of the bill. Yes, Chairman of the committee.
Mr. Speaker, Clause 3, amendment proposed, paragraph
Clause
F.
3 what? Your
Paragraph
amendment
F.
is F.
Yes, paragraph F. Line 1, delete government and insert minister.
Honourable members, that is the proposed amendment for your consideration. In the absence of any further proposal, I'll put a question on clause 3F as amended by the committee and captured by the Unomi committee. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 3F as amended is ordered to stand part of the bill. Now, I am to put a question on the entire clause 3, and it is for consideration of the House. Yes, Honorable Dr. Kabiru.
Thank you very much, Mr. Speaker. Right, Honorable Speaker, I'm proposing further amendments to I, and I'm proposing the deletion of that are not required for immediate use. And the new rendition will read, invest the funds of the council as the council considers appropriate. Mr. Speaker, the reason for this proposed amendment is to avoid the absurdity of what constitutes what is not needed for immediate use. And because we have already provisioned for the fact that the council will determine as appropriate, it amounts of flogging that particular provision by stating that unless, of course, we want to define what means by not needed for immediate use. Otherwise, I prefer that we keep it simple as proposed. Invest the funds of the council as the council considers appropriate. So I so move, Mr. Speaker.
So, honourable members, the proposal is to delete that are not required for immediate use, so that the new rendition will be invest the funds of the council as the council considers appropriate. Honourable members, I'll put a question. As many as are in favor of the proposed amendment, yes?
Yes. You invest monies that you don't need for your immediate use. So that is, a way of making it very explicit that when the council has idle funds, those funds must be invested.
So, in all those circumstances, is it not something that the council is going to consider whether it is appropriate or not appropriate? So his argument is that because we are saying the council must do investment as appropriate, it encapsulates the fact that if the money is idle, the council is supposed to invest it. Because it will be inappropriate to do investment where there is immediate use of the money. That is his argument. And supported by the brevity principles, I want to put a question on it. Yes?
Mr. Speaker, I don't think that deleting it will do any violence to the language. So
yes.
I agree we can delete it.
Yes. As many as are in favor of the amendment proposed by Dr. Kabiru to clause 3I, say aye. Those against say no. The ayes have it. The amendment proposed to clause 3AI is ordered to stand part of the bill. Now, honourable members, I can put a question on the entire clause 3. Yes. Honourable Dr. Chia Samuel.
Mr. Speaker, thank you for the opportunity. I would like to propose an amendment to 3J. It says collaborate with other bodies or organizations within or outside the country that the council considered necessary to achieve the objective of the council. Per the current renditions that I've seen in other acts, if we can insert the word collaborate with other relevant either bodies or institutions. So collaborate with other relevant.
So in the circumstances, who determines whether the body or organization is relevant or is not relevant?
That would be the council. The council.
What criteria will you use to determine that?
Yeah.
What criteria will you use to determine that?
The council will use its own standards to determine which one is relevant.
No, we don't legislate like that. Because I can go to court to say that you are collaborating with this institution, but I feel it's not relevant, so the court will determine.
Mr. Speaker, the council would be the one that would determine.
Yes.
Because I'm looking at the other education regulatory bodies at any.
This is collaborate with. I thought you are going to say the Interpretation Act is clear, so we should not use the word bodies or organizations, and then we use persons, which includes bodies and organizations, or the drafters. Is that not the way it is? We should use persons instead of bodies and organizations. Very well. That will happen in the event that they want to collaborate with natural persons. But apart from that, he said collaborate with other bodies or organizations within or outside the country that the council considers necessary to achieve the object of the council. So once it is here by Dr. Kabiru's argument, as the council considers necessary, the council will not consider any irrelevant body to have been collaborating with. So it makes the use of the word relevant odious. Yes, Dr. Kinsinyako.
Mr. Speaker, with respect, if you will indulge me to paragraph G, evaluate courses.
But the practice is that if there is an amendment on the floor, let's agree, disagree, whether to put a question or not to put a question before we move to another clause.
You are right. I yield.
Well, members, I think we have to leave the rendition as it is. So this is the point for you to propose any amendment to any other clause.
So G, I'm proposing evaluate, instead of courses of study, evaluate curricula provided by accredited institutions or accredited institutions, as you said. This is because accreditation institutions don't normally accredit courses. Normally, it is a curricula. The curricula consists of courses and other requirements. So I'm suggesting that instead
but
of...
remember, we are saying that it will extend to cover professional training institutions, such as the law school.
No, I'm referring to the courses. The rendition now is evaluate courses of study. And I'm saying that if we could make it evaluate curricula instead of courses.
The training institutions, are they going to have the curricula or they will have courses? Because if you look at clause 62 of the bill, you can go and look at it. 62. Law practice training.
Mr. Speaker, so maybe that is what pertains to the law program, but what I know is that we normally don't accredit courses but programs or the entire curricula because the courses are components of the program, unless in the law program we deal with only courses.
Because, otherwise, for instance, at the professional level, what you do is the professional law course.
Have a program.
So we study professional law course, part 1 and part 2. And that is going to be there by way of clause 62 of the bill. So I'm wondering whether what you are saying should be the terminology should be right.
That's what I'm saying, that because it is it's a legal program, because normally programs are made up of courses. But if in this case, the legal program deals with courses, then this rendition would
in
be
this
okay
context, the legal program that we are talking about includes LLB and the professional training course and the bar exams before you can be a lawyer.
That's what I'm saying, that normally the curriculum comprises all the courses, all the activities that make up the program.
So it is for the consideration of the House. Yes, the sponsor. The suggestion is that we should delete course of study and insert, yes, AG.
I think we should maintain the language of the bill, the course of study. Because, Mr. Speaker, as you rightly pointed out, if you look at clause 62, it's very specific with respect to the courses of study that you need to undertake in order to be able to be certified to write the National Bar exam. So it's the courses of study. It's not the entire curriculum that we are dealing with.
Yes.
Mr. Speaker, I partially agree with him. But senior, you are my senior at the university, and you don't evaluate courses in isolation. You don't do that in isolation. You do it comprehensively. The course is part of a structure. So when the course is affected, it also affects other requirements. And these requirements are also captured in the broader curriculum. That is why I'm making this proposition.
Well, the proposal from the sponsors is to maintain the language as used in the bill. If you feel so strong about your proposal, move an amendment.
Mr. Speaker, I beg to move that in paragraph G, we delete courses of study and include curricula, making the rendition evaluate curricula provided by accredited institutions. I so move.
Honourable members, I am putting the question on amendment proposed by Honourable Professor Kinsley Nyako. Those in favour say aye. Aye. Those against say no. Honourable members, I cannot put a question on entire clause 3. All those in favor of clause 3 as variously amended, standing part of the bill, say aye. Yes.
Right, Honourable Speaker. If you look at clause 3K, it seems incomplete. From the original bill, it was perform any other function that is incidental to the achievement of the object of the council. But it appears that the sentence is incomplete there. So, Mr. Chairman, do you want to move for? No, I'll let the chairman do.
Mr. Speaker.
Yes.
Yeah, the K paragraph, clause 3K is incomplete, and I want to move that it is inserted with the following of the object of the council. So the rendition will read, perform any other function that is incidental to the achievement of the object of the council.
Thank you very much for that observation. We are grateful, AG. I will then put a question on K. Those in favor of the proposed amendment say aye. Aye. Those against say no. The ayes have it. Clause K, as amended, is ordered to stand part of the bill. Yes. I will then put a question on entire clause 3. As many as are in favor of clause 3 as variously amended, standing part of the bill, say aye. Aye. Those against say no. All members, the ayes have it. Clause 3 as variously amended is ordered to stand part of the bill. Clause 4.
Governing body of the council.
Chairman of the committee.
Mr. Speaker, respectfully, I want to bring something to your attention before I proceed. Mr. Speaker, I want to refer you to Order 170D, and subject to your permission, it says that where an amendment on the order paper exceeds 4 lines, it shall not be necessary for the member moving the amendment or the speaker in putting the question to read out the amendment if the place in the order paper where the amendment appears is pointed out.
Yes.
Mr.
So
Speaker,
what you say is that, Right Honourable Speaker, I move the amendment as captured.
Very well.
That's what you do.
Very well, Mr. Speaker.
Yes,
So-
when it exceeds the line, that's what you do.
Very well.
Yes.
So clause 4, amendment proposed, subclause 1, delete and insert the following as advertised on
No,
page.
yes.
On page 5.
Yes. So, honourable
And 6.
members, the advertised amendment is per the winnowing committee's bill as clause 4. So it is for the consideration of the House. Yes, Honourable Boama.
Thank you very much, Right Honourable Speaker. Mr. Speaker, clause 4A, 1A, I want to propose for the deletion of or a person who qualifies to be appointed as a justice of the Supreme Court. And then the proposed rendition then will become one retired justice of the Supreme Court nominated by the President as chairperson. Mr. Speaker, I make this proposal because if you check the appointment that is being considered here, you're looking at a retired Chief Justice. A retired Justice of the Supreme Court, a retired Justice of the Supreme Court. And so if you want to create another leg, which is suggesting another person who qualifies to be appointed, I think that is a bit problematic because in terms of someone to chair the council, there shouldn't be any difficulty in getting a retired justice of the Supreme Court. And then if you link it to an appointment of anybody
Well, Honourable Boama, do you know the age of the retiring of the Supreme Court? 70 years.
Yes, Mr. Speaker, 70.
So do you envisage a situation where we will not have a retired justice of the Supreme Court? They will all be sitting Supreme Court justices?
Yeah, Mr. Speaker, exactly that's my point. If you check...
So you don't kick against this rendition? Because
No,
if you kick
Speaker.
against this rendition,
Speaker,
where it is possible that we don't have a retired Supreme Court judge, what happened?
Then Speaker, what happens then for me would be for us to appoint someone who is a Supreme Court,
No,
justice.
you see, having regard to the workload of the Supreme Court judges, that is why they don't want to give this to a sitting judge. So if the person is retired, then he has the time to do this particular work. But in the event that we don't have any retired Supreme Court judge, anybody who is qualified to be a Supreme Court judge, but he is not a judge, is qualified to be appointed. That is the essence.
But Speaker, the essence for me why they chose a retired Supreme Court judge is because of the experience. And we've had our Council of State composition that always have a retired Supreme Court judge, though we've never envisaged in the absence of no one being a retired Supreme Court judge. And so, Speaker, fairly, I think, and if you check the composition of the Board of Legal Education in Act the 1960 Act, the composition had the Chief Justice as chair. The Chief Justice as chair. It's for good reason. And so if we are bringing in this council where a retired Justice of the Supreme Court is supposed to chair, I think there's a bit of a difficulty relying on any other person that qualifies to be a justice of this. That is my thinking. And we should be very guided based on the previous.
You see, if care is not taken, having regard to the retiring age at 70, this is subject to the person agreeing to do it. Somebody who has been a judge and he is now 70, having regard to the work of the council, may decide that no, I don't want. So if among the retired Supreme Court judges, nobody is willing to do this, or in the event that you don't have a retired Supreme Court judge, if you don't have this particular alternative, who else takes the job? Let me give you an example. Honorable Sami Okujeto is not a retired Supreme Court judge. He's never been a judge. Are you saying that having regard to the number of years that he has spent at the bar, he cannot be? Do you understand? So let's say, let's even talk. The Right Honorable Speaker is a renowned lawyer. He's never been a Supreme Court judge, let alone to be a retired judge. Are we saying that having regard to his experience as a lawyer and as a legislator, he's not qualified because he's not a retired Supreme Court judge? He doesn't have the experience. That is why they are saying that a person who is otherwise qualified to be a Supreme Court judge.
Speaker, I clearly understand the intendment, but similarly, you can have the executive or the president appointing a novice as well of 16 years. Oh, why? If I say, no, we're talking here about experience. All the references that Speaker made is legitimate to the extent that you can find an experienced person.
Honorable Boma, are you listening to what you are saying?
Oh, Speaker,
a person who is otherwise qualified to be a Supreme Court judge can be referred to as a novice.
Speaker, I use that advisedly. So no. I can withdraw the word novice.
Yes.
I withdraw it accordingly. Speaker, I withdraw that accordingly.
The
Speaker,
Constitution gives the power to the President. Are you challenging the constitutional powers of the President? He does the appointment under a particular constitutional provision. Honourable members, I beg you, let's be careful about some language that we use.
Speaker guided, and I think I have withdrawn. Yes, I withdrew it, and so I think we can make progress. But I have nothing more to say than the extent that the intendment here, getting one retired Supreme Court justice to chair and creating the alternative as another person who qualifies to be appointed to the Supreme Court. And I'm referencing it against our old provision, legal provision, where bodies of this nature, we've had even the Chief Justice chairing for good reason. So that is my proposal.
If you read the entire bill, you will realize that the work of this particular council is not going to be as simple as a general legal council, because they are extending, broadening. So the work will be very involving. General legal council, the sitting Chief Justice can afford to do that. But I believe after creating this particular law, if you ask Chief Justice to be a member of this, it's going to be a bit problematic, because you are extending it to even the LLB level. It's not only the Ghana School of Law or the professional law course as usual. You are extending it to other universities who are accredited to do both the LLB and the professional course. So this will be evolving. Now, if you don't have this particular clause here, the person may be even a law lecturer for several years of experience, but because the person is not a judge or retired justice of the Supreme Court, the person is disqualified. Is that what we are talking about? For instance, Professor Kofi Kumado cannot be a chair of this. He should be disqualified. My sweet constitutional law lecturer should be disqualified. Yes, Professor Makokwe, it should be disqualified because he's never been a judge or a retired judge. Please. Yes.
Thank you very much. Speaker, I think it will be fair to find out from the Honorable Respected Attorney General the basis for the departure. Because, you see, I also believe that there is a clear intent why the Chief Justice originally is the one who has been presiding over the council. And he is active and strong and he is sharp at that point. So if you are bringing in a retired Supreme Court judge or any other person who is qualified to that at that level, we should know why. Because perhaps if we know why, it would solve all the problems we're going around to try to seek answers for. If I know that, maybe the belief is that the retired Supreme Court judge is not going any work to do. He has all the time and is very experienced, and that's the basis for which he's the one to be considered. It could be some reasonable response. Yes.
Do you look at clause 1? That is established by this act, the Council for Legal Education and Training as a body corporate. Is this council not different from General Legal Council?
Speaker, it is, but we also always take a cue. That is the basis for studying history. The reason why we do some of these things is to also look at what has transpired.
For me, I think it's obvious, but if you want the AG to speak, I will give the floor to the AG.
I don't know, but if you
speak.
think it's obvious, I don't think it is, really, respectfully.
It's obvious. AG, they want to hear your voice. Yes?
Mr. Speaker, I think there's something there that we should look at. Because if you are looking for somebody qualified to be a Supreme Court judge, look for that person. If you are looking for somebody who's already served as a judge at the Supreme Court level, then look for that. But you cannot equate a judge who has served and retired as a Supreme Court judge with somebody who qualifies to be a Supreme Court judge. So I think there's something there that we should actually pay attention to. Are you looking for somebody who has gone through the entire system, has been a Supreme Court judge, knows everything, and has now retired? Or are you just looking for somebody who is qualified to be a Supreme Court judge? What was really the intention? Because what somebody who has been a Supreme Court judge already and retired brings to the table is different from what somebody who qualifies to be a Supreme Court, which is just 50 years at the bar, brings to the table. So let's hear from the Attorney General. What experience do you desire for the, what do they call it? The chairperson of the council. What kind of person are you looking for the chairperson of the council?
I'll give the floor to the Attorney General, but before doing so, by practice and convention, anytime we talk about a high court judge, we even say a lawyer who is qualified to be a high court judge. So this is not the first time in legislation that we are doing that particular analogy, but I'll give the floor to Honorable
Mr. Speaker,
Attorney General.
Right Honorable Speaker, thank you very much. Mr. Speaker, I think you answered a question earlier when you mentioned Professor C.E.K. Kumado and asked rhetorically whether he could not be the chairperson of this council when it is established. That is the intendment here. In the discourse leading to the drafting of the provision, we took the view that for a Supreme Court judge to chair, they are already, they already have a lot of work on their hands. In fact, the Chief Justice presided over this amendment when I met with the General Legal Counsel to deliberate on issues affecting this bill. And we came to the conclusion that a retired Supreme Court judge with the experience that, that person will have, can chair the council. But let's say an academic or a legal practitioner who has many years of experience. The Honorable Kwame Imedu is 30 years at the bar. Why can't, if he leaves Parliament, why can't he be the chair of that council? Because apart from being, a lawmaker, a legal practitioner, he has also taught law at the KNUST Law School before. So these are the kinds of, persons we are looking for. We are contemplating. So, Mr. Speaker, I think that we deliberated very, very well on this matter before we came to a conclusion that we should, seek for qualifications or experience equivalent to that of a Supreme Court judge, but when it comes to the chairperson, we want a retired Supreme Court judge. Thank you, Right Honourable Speaker.
Yes, Honourable Jerry Ahmed.
Speaker, thank you very much. Let me thank the AG for this clarification. But Speaker, this is where I still have an issue. Speaker, if you go back and you look at or a person who qualifies to be appointed as a justice of the Supreme Court. Speaker, we know that several lawyers qualify to be appointed as Supreme Court judges. Those lawyers, Speaker, some of which are very well known to us, they applied to be Supreme Court judges and they were declined. So, to qualify is not the same as you have qualified. To the extent that if you qualify, it means that you have sat on the bench. Well, Speaker, it may sound funny to some people, but if you have qualified, it means that you have practiced, you have been on the bench, and for which reason you have retired. And that is why the retirement bit comes in. Speaker, it is okay for this House for us to indulge people to listen to their views. This is practical. We should be looking at how many years you have practiced and what would be the basis for that qualification. Because, Speaker, I know even some of the names that were mentioned here. Some of them are more than qualified, but they were rejected. But how is the person qualified if the person has been rejected?
Honourable Deputy Whip, what is the constitutional language in qualification to a Supreme Court? Is he a person is qualified or a person qualified? So sometimes you cannot be wrong using the constitutional language. The fact that you qualified, you applied, but you've been declined, doesn't mean that you are not qualified to be.
Speaker.
So
just
other factors are taken into consideration.
Speaker, just a quick one, just to seek AG's consideration. If the challenge for a retired justice of the Supreme Court is what is difficult, AG, can we consider one retired justice of the Superior Court?
There will be a lot of them.
Of the Superior Court, because then from High Court, Superior Court, you have High Court, you have Court of Appeal, you have Supreme Court. And if you say retired, any of them would have been at the bench and served for like 10 years, inclusive of their appointment to the High Court or Court of Appeal, and that gives us a bigger room to choose from. My concern is about the level of experience you want to bring onto the table to chair that council. So my counter proposal would be one retired justice of the Superior Court.
So let me ask, if you make the rendition like that, what happened to somebody who has never been a judge, but yet can perform that function?
But Speaker, once AG, we had...
No, you are not answering my question. The question that I'm asking you is if your rendition is anything to go by.
Yes.
What happened to somebody who is not a judge, but he has the experience and qualified to occupy the position?
If the president in appointing someone has a plethora of people to choose from, what is our difficulty if the president can find a retired justice and not have to take from anybody who has a couple of years at the bar, particularly when the first leg of it is a retired justice of the Supreme Court. So that
I
is
think
the level
rendition as it is qualified. Particularly, I do not have any counter amendment. I intend to put a question. As many as are in favor of clause 4 as amended, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 4 is ordered to stand part of the bill. Clause 5.
Functions of the board.
Chairman of the committee.
Clause 5, amendment proposed. Delete entire clause and insert the following as captured on page 6 of today's order paper.
Honourable members, the amendment is on clause 5. Is for the consideration. Any member who has a further amendment, please do so. Do you have amendment on clause 5?
Please, Speaker, please hear me. The clause 4, we did the A. And I had...
Honourable member, we are on clause 5. I really do not like what you are doing. I really do not like the behavior you are putting up.
No,
please, it's not the best.
Speaker, I can seek your leave.
It is not the best. In amendment process, you don't insist. Even where everybody feels that you are wrong, you are still insisting. And we move to clause 5, you are taking us back to clause 4. Honourable member, kindly resume your seat. In the circumstances, resume your seat. Honourable members, amendment proposed by the chairman of the committee, clause 5. It is for the consideration of the House. Honourable members, in the absence of any further amendment, I'll put a question. As many as are in favor of clause 5 standing part of the bill, say aye. Aye. Those against, say no. The ayes have it. Clause 5 is ordered to stand part of the bill. Clause 6.
Tenure of office of members of the board.
Chairman of the committee.
Clause 6, amendment proposed, subclause 2, line 1, delete registrar and insert director general.
Honourable members, that is a consequential amendment to clause 4. I'll put a question. Those in favor of the proposed amendment by the chairman of the committee and consequentially to clause 6(4) say aye. Aye. Those against say no. The ayes have it. Clause 6(2) and 4 as amended consequentially are ordered to stand part of the bill. Yes, chairman of the committee. I'll have to put a question on the entire clause 6. As
clause.
Yes.
Speaker, on 6(3), it reads a member of the board may at any time resign from office in written address to the president through the minister. Yes, I will propose that the address, we make it open because you have situations where there are institutional representatives. And so in such situations, those people should be able to write their letter to the institutions that appointed them. And so, Mr. Speaker, yes, institution that nominated them. Leader. Yes, so you are saying that the letter to the institution is not necessary and that it all should go to the president. Well, I believe that even though it's the president that does the appointment, it is the institution that nominates the people to the president for appointment. So the person resigning should be able to write to the institution that for this reason, because there's an institution that will bring a new person to represent him. So I believe that the letter to the institution will be a good thing. Leader. So a member of the new rendition should read, a member of a board may at any time resign from office in written address to the institution that nominated the said person.
I don't get your amendment. Which of the provisions are you amending? You are talking about 5?
Mr. Speaker, I'm talking about
6(5).
6(3).
6(3).
Yes. And I get the argument that is a president who eventually appoints because of Article 70, but the institution that nominates the person should be the recipient of the letter of resignation from the person.
Well, the 3 is saying a member of the board may at any time resign from office in writing address to the president through the minister. So the president is appointing authority.
I'm saying
so
that there
when the president,
yes,
listen to me. So such a person, the law makes provision for replacement. So if you are appointed to serve the interests of Parliament and you have written to the appointing authority that I do no longer want to represent Parliament on that particular board, the appointing authority will write a letter to the institution to bring another person to replace. That's why if you read further, there is a provision for how those people are supposed to be replaced. So your concern has been addressed. Once it is institutional representation, if you are not there, it is the institution that must bring. So a vacancy is created.
Exactly.
And once the vacancy is created, the appointing authority must get the nomination from that particular institution, irrespective of whether or not you write to the institution or not.
Well, that's
what happens if you are representing road sector on a board and you've decided to resign from the road sector, to resign from the committee, and you've not communicated it to the road sector?
Exactly the point I'm making, Mr.
Yes.
Speaker. So we are on the same wavelength.
But you are not appointed by the road sector to serve on that particular committee. You are appointed by the president.
Okay, so Mr. Speaker, just allow me. I mean, I'm ready to concede if I'm convinced. But my point is that if an institutional representative is resigning, is it not okay that he informs the institution that appointed him? And then the institution would tell the president that, well, we have our member has resigned, instead of writing to the minister, writing to the president through the minister before it gets to the institution that sends the person there.
You see, this particular law set out the requirement that A must come from this institution, B must come from this institution, and at the end of the day, they are all appointed by the president. So the president is the appointer. So the president, being the appointer, knows the composition of that particular board. So if you, in particular, you are serving the interests of EPA, and your communication is to the president that I no longer want to serve that particular interest, the person who appoints you, all that the president will do is to request EPA to bring another person. So the information will come from the president to EPA. I'll put a question on clause 6. As many as are in favor of clause 6 standing part of the bill say aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part of the bill. Clause 7.
Meetings of the board.
Having taken the amendment on clause 6.
Yes, I've taken the consequential amendment. That's why I said
Very well.
consequentially.
Very well.
Yes.
Very well.
Clause 7. Chairman of the committee.
7, amendment proposed, subclause 1, line 1, delete 2 and insert 3.
It is for the consideration of the House. Honourable members, in the absence of any further amendment, I'll put a question. All those in favor of clause 7, subclause 1, as amended, standing part of the bill, say aye. Aye. Those against say no. The ayes have it. Clause 7, subclause 1 is ordered to stand part of the bill. Yes, Chairman of the committee, still clause 7.
Clause 7, subclause 4, line 1, delete 6 and insert 7.
Honourable members, it is for the consideration of the House. Any further amendment? Honourable members, in the absence of any further amendment, I'll put a question on clause 7, subclause 4, as amended, standing part of the bill. All those in favor say aye. Aye. Those against say no. The ayes have it. Clause 7, subclause 4, as amended, is ordered to stand part of the bill. Yes, Chairman of the committee, still on clause 7.
Mr. Speaker, we have a new clause after.
New clause. I thought this is part of amendment of clause 7. Honourable members, I will then put a question on entire clause 7. As many as are in favor of clause 7 standing part of the bill say aye. Aye. Those against say no. The ayes have it. clause 7 is ordered to stand part of the bill. Yes, Chairman of the committee.
Mr. Speaker, new clause amendment proposed. Insert the following new clause after clause 10. And say
Well, Chairman, then if that being the case, we have to take clause 8, 9, and 10 before taking the new clause.
Very well, Mr. Speaker.
So, clause 8. Chairman of the committee.
Mr. Speaker, clause 8, there is no advertised amendment. The next.
Put your microphone off. Yes, clause 8.
Disclosure of interest.
Clause 8. Do you have advertised amendment? Speak into the
No
microphone.
advertised amendment.
All members, it is for the consideration of the House. Any proposed amendment to clause 8? Honourable members, in the absence of any proposed amendment, I'll put a question on clause 8. All those in favor of clause 8 standing part of the bill say aye. Aye. Those against say no. The ayes have it. Clause 8 is ordered to stand part of the bill. Clause 9.
Establishment of committees.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 9? Honourable members, in the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 9 standing part of the bill say aye. Aye. Those against say no. The ayes have it. Clause 9 is ordered to stand part of the bill. Clause 10.
Allowances.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any proposed amendment to clause 10? All members, in the absence of any proposed amendment, I'll put a question on clause 10. All those in favor of clause 10 standing part of the bill say aye. Aye. Those against say no. Clause 10 is accordingly ordered to stand part of the bill. Now, Chairman, your proposed amendment.
Clause 11, there is no proposed amendment.
Order paper. You are proposing a new clause, which will come after clause 10.
After clause 10, very well, Mr. Speaker. That is after 8. 1 second.
Please look at the new clause after clause 7.
Yes, Mr. Speaker. The new clause, amendment proposed, inserts the following new clause after clause 10, as captured on page 7 of the order paper for today.
Honourable members, this is a standard provision.
It's actually page.
It is for the consideration of the House. Yes.
Honourable Speaker, the amendment is saying Director General of the Legal Education. But if you look at the current renditions that we have passed in this House, it's more of appointment of the Director General. So, and also if you go down to the subclause 1, instead of saying appoint a Director General of Legal Education, we can also make it appoint Director General of the Council, as has been done in the recent renditions that have been passed.
Yes.
The council. So instead of so I'm proposing that the new clause,
the Director General, is he the Director General of the Council? The Council is a governing body. You understand? But we have a legal education, and they are appointing a Director General for that legal education. Yes.
But if you look at the memorandum, it talks about establish the Council for Legal Education and Training. So that is an umbrella body. So if you're appointing a Director General, it should be a Director General for the Council for Legal Education and Training. You cannot just say Director General for Legal Education. What is that?
Yes, Chairman of the committee, or the AG, once we are here as a sponsor.
Mr. Speaker, I believe that the rendition should be okay. The Director General, of course, is being appointed under the board, and I think it's convenient, it's okay.
Yes, Honorable Animedu.
Mr. Speaker, I should think that the Director General here would act as the Chief Executive as such. So the chair, the council must have a chairman. There could be a chairman of the council, but if you read the next section, it says that the Director General shall be responsible for the day-to-day running of the institution. So you can have I think what is there is right. The chair must be not the Director General for the council. He could be a member of the council, but the Director General is in charge. So like the Chief Executive of an institution. Right. So that is right.
Yes, AG.
Yeah, Mr. Speaker, currently we have the Director of Legal Education. And the Director of Legal Education is the head of the Ghana School of Law. But because we are creating a whole council that will decentralize the professional legal education to the universities, we thought it wise to elevate that person to a Director General status. And that will be the Director General of Legal Education as captured in this bill. So I think this rendition should stay. Thank you, Mr. Speaker.
Yes, Honorable Animedu.
Mr. Speaker, safe to add that there must be a head note of this new clause that should be appointment of the Director General of Legal Education. So I'll move that there should be a head note, appointment of the Director General.
Yes. Chair, someone.
Yeah, Mr. Speaker, thank you. If you look at clause 1, it says that there is established by this act a council for legal education and training as a corporate body. And the head of this corporate body, I believe, is going to be this Director General. It's not going to be just a head of a part of this body, not the head of a department. So can they tell us who is going to be the head of this corporate body? And that is why I asked that we have the head note of the appointment of the Director General. Then also, when you go there, appoint Director General of the Council for these two programs.
Yes, Attorney General.
Mr. Speaker, if the honorable member had read clause, I think it's clause 11.2. No, not 11.2. That is 12.1. Sorry, Mr. Speaker, clause 12.1. The Director General is responsible for the day-to-day administration of the Council. So it puts the Director General as the one that manages the day-to-day affairs of the Council. But the Director General is the Director General of Legal Education, not the Director General of the Council.
So, Honorable Chair Samuel, a council has been established, and that council is responsible for legal education in the country. And the Director General will be responsible for the day-to-day administration of the council that is responsible for legal education in the country. Your problem is, why is that person being called Director General of Legal Education but not Director General of the Council? Is that your problem? Well, I would say this is just a nomenclature. Yes. Yes, Majority Leader.
Yeah, Mr. Speaker, we have an Act of Parliament establishing the Council for Scientific and Industrial Research. The Council for Scientific and Industrial Research. It has a council, which is the governing body, same way that we have a council that is the governing body of legal education. We have a Director General. The Director General is not the Director General of the council. He is the Director General for, scientific research. So that's how it is structured. Because the council, as a council, is simply, you see, when you say Council for Legal Education, that encompasses the gamut of work that is involved in running legal education. Then there is council as the governing council of legal education. So the Director General is not like a secretary of the council. The Director General, he will serve that function. Very often we say he is a secretary at the meeting of the council, or we even make him a member of the council, but he is the Director General of legal education. So he does the day-to-day work, he does everything, he is the administrator, all the staff that perform the administrative work are under him, and then he now answers to the council. That's how it is structured. So we can never have Director General of a council. It's Director General of legal education.
Honorable Chair Samuel, how do you propose that the Director General be called?
Thank you very much, Mr. Speaker. Before I come there, we have the governing body, which is being stated here.
How do you propose?
So I'm proposing
the
that
Director General to be called, if not a nomenclature. Just do your proposal.
So I'm proposing that we have the head note appointment of the Director General first. Then I'm also proposing that appoint a Director General of the Council, since we have a body, a governing board that is going to take care of the Council, because we have a corporate body that has been established. And since the corporate body that has been established, the entity is if you look at clause 1, the body that has been established here.
Honorable Chair Samuel, by
the
this
body
law,
that has been established here is
by
the
this
Council
law,
for
I see your argument. By this law, do we have a legal education?
So, no,
we have a legal
education
education by this law.
Legal education is part of what the council will be doing.
Yes.
Because the entity that we are having a Director General for is not just for a part of it.
Wouldn't it sound better to say a Director General of Legal Education than a Director General of the Council?
If legal
because
education is the corporate entity,
the name depicts what the person is going to do. You understand? How do you say Director General of the Council when the Council is responsible for legal education? So if you mention that person to be a Director General of Education, it's far better than saying a Director General, because he's going to be in charge of legal education anyway, day-to-day running.
Speaker, if you should state Director General of the Council for Legal Education and Training, then I will agree. But if you state Director General of just legal education, that is where, because...
Well, propose amendment and let me put a question.
The corporate body we are trying to
propose amendment and let me put a question.
The amendment I'm proposing here, Mr. Speaker, is to have the head note, appointment 1. The first proposal is the appointment of the Director General. Then 2, we have the appointment of the Director General of the Council for Legal Education and Training, if that is the corporate body.
Yes, I'll put a question on the amendment proposed by Honorable Che Asamoah. Do you have a counter amendment? All those in favor of the amendment proposed by Honorable Che Asamoah, say aye. Those against, say no. Honorable Member, your amendment is rejected by the House. Honourable members, honestly, I don't have a problem if the head note is Director General, and then the body goes to stay. The President shall, in accordance with Article 195, appoint a Director General of Legal Education. The Director General shall hold office on the terms and conditions specified in the letter of appointment. So if the framers of the law says this is how you want to be called. Yes, Honorable Anyimedu.
Mr. Speaker, I would love that we go with the appointment of Director General, because if we just title it Director General, then we don't need the next one which talks about functions of the Director General.
Yes, that is fine. We can add the appointment to it.
Yes.
I will agree to that.
So the appointment of Director General must be the head note. Thank you.
Yes. Yes.
Mr. Speaker, I don't think the clauses following deal only with appointment. I think the clauses following deal with so many other
it's true.
issues. So you cannot limit.
And all those issues relate to Director General.
Director General.
So we can make
you
the
have
head
to
note
leave it as
Director
General for legal education. Then you have a clause that deals with his appointment. Another clause deals with his functions. Another clause deals with several other issues. So it's generally Director General of Legal Education. Then all the clauses pertaining to that office will follow. But if you say we should say appointment, then you are restricting us to just appointment.
Honourable members, because it's an insertion, and then the 11 is also dealing with Director General of Legal Education, I will direct the drafters to rearrange and put the provisions at their deserving places. So the drafters will take note and do this for us. Yes, clause 11.
Director General of Legal Education.
Chairman of the committee.
Mr. Speaker, no advertised amendments.
Honourable members, it is for your consideration.
Yes. 11. Yes. So, okay. Mr. Speaker, I move that the entire clause be deleted.
Honourable member, move the amendment correctly because the new clauses are in 1, and there is also a new clause in XII. It's a new clause. So move XIII.
So, Mr. Speaker, I move that after clause 10, the following clauses be inserted as per page 7 of the other paper, page 7 and 8 of the other
members, paper. Amendment numbered at page 7, XIII, moved by the chairman of the committee, and it is for the consideration of the House. All members in the absence. Yes.
Mr. Speaker.
Yes, let me hear you first.
Yes, Mr. Speaker, so that would be the functions of the Director General. Is that what we are looking at?
Yes.
So, Mr. Speaker, I'm looking at clause, so it will be, is it 12 or 11? But I think I'm looking at the L.
New clause 2, L.
So L, that the Director General shall evaluate foreign legal qualifications for equivalence and facilitate reciprocal arrangements with institutions in analogous jurisdictions. Mr. Speaker, I will propose that this particular function is given to the council. I say so because, Mr. Speaker, I think that to leave this job of evaluating foreign legal qualifications to the Director General alone would not be a good idea, and that if this is given to the council will do a better job than to leave the Director General alone to evaluate foreign legal qualifications. And so I propose that this particular provision is moved to the functions of the council.
Well, Honorable AG, he is saying that the evaluation should be done by the council rather than the Director General. That is the L. Sorry. Yes, Dr. Kabiru.
Mr. Speaker, my sense is that we are in clause 11. Clause 11, no, your proposal is 12, right? But we're still in 11.
You see, clause 11 is the work done by the winnowing committee, which has integrated the proposed amendment by the committee. So I even advise the vice chairman of the committee that in moving the amendment, he should say as captured by the winnowing committee in clause 11. But he chose to go by the order paper instead of what I told him. You understand? That is what is making members confused. Because the document that we have before us have the integration of the amendment into the bill. You understand? So clause 11, the entire clause 11 has taken accounts of the proposed amendments. And then the functions are what we are considering now as in clause 12, per the work done by the winnowing committee. Then the appointment of the registrar, which used to be initial clause 11, has now become clause 13. Yes.
So therefore, it means that it should have been moving the amendment in respect of clause 12. When we pass it, then we go to clause 12 in that order.
Yes, because this one has done the rearrangement already.
Exactly.
That is why yesterday I admonished members that we should be proposing further amendment in line with the work done by the winnowing committee.
Yeah, so Mr. Speaker, direct sort of can go accordingly.
Yes. Yes, so you can move the whole clause 11. You understand? As proposed by the committee and adopted by the winnowing committee, so that the members will now base their amendment on what is in this law. Then we come to clause 12. Yes.
Mr. Speaker, I'm almost getting confused. I think what the chairman is doing is apt. He has the order paper and it's been advertised. He moved them as new clause. He's moved the second clause. This new one, which is done, which incorporated one, is a guide. So, Mr. Speaker, so far as this House is concerned, this document is not known. Let us go by that. We are almost there. And
you see, Honorable Animedo, that is the problem I have with you. What is the essence of the winnowing committee? The winnowing committee is supposed to invite all those who have a proposed amendment to a bill, agree or disagree with them. Now, whatever they have agreed upon then becomes a component of the bill. And whatever has been disagreed is brought to the House. That is what Order 168 is saying. That's why yesterday I advised that if such being the case, once these amendments have been integrated into the bill, let the House look at the integrated amendment and carry out further amendment on the integrated amendment. And we urge members to take a copy of the integrated amendments. That was what informed my advice to the chairman of the committee, that you do your proposal as captured by the winnowing committee in clause 11. You come to clause 12 as captured by the winnowing committee in clause 12, so that any member who has a further amendment to the work of the winnowing committee, the member will then proceed to do the amendment. Other than that, we risk the chance of members doing their proposed amendment based on the bill before the winnowing committee. Yes. That is what is causing the confusion. Yes.
So my understanding is that we are at clause XIII.
Yes, which is the clause 11.
Which is?
No, the XIII is the clause 12 of the bill.
Yes, so clause XII.
Yes, which is clause 12 of.
Which is now clause 11.
12. No, it's now clause 12. XIII is dealing with the functions of the Director General. Clause 12.
Yes, so that's what I'm talking about. So XII, but XII is clause 11. XIII.
Yes, it's clause 12.
It's clause 12.
Yes.
That is. So the issue is that he should move according to.
So we just dealt with clause 11.
We are done with clause 11.
Yes.
So he should move clause 12.
With clause 11. Yeah.
We're now at clause 12. Yes. It's not confusing. No, but that's what we've been doing since we started. And everybody's using the incorporated bills. Everybody's using that. So all the proposed amendments that your side has been moving is based on the amended, incorporated bill that we are working with.
Honorable members, the first new insertion is under the head note Director General, Legal Education. That was what Che Asamoah proposed an amendment to. And I put a question and the amendment was lost. So we are now moving to clause 12, which is on the order paper as XIII, dealing with the functions of the Director General. So that is where we are now.
Mr. Speaker, he moved it and I proposed an amendment. And so the amendment was for the consideration of the House.
Yes. So we are now at clause 12, which is the order paper XIII.
Yeah.
Yes, Honorable Dr. Kabiru, why are you saying no?
I say no because when the proposed amendment by Dr. Che was put and it was not carried, we did not put the motion or vote to the whole of 11. We did not do that. And I have amendment. I have amendment in respect of 11.
Very well. Then let's come back to 11. Propose your amendment.
Mr. Speaker, I propose after legal education, insertion of and training. Mr. Speaker, the new rendition will then read, the President shall, in accordance with Article 195, appoint the Director of Legal Education and Training. Mr. Speaker, I make this amendment because the Council, which we see, envision that the Director General is supposed to carry on day-to-day administration of the Council, is a Council for Legal Education and Training. If we omit the training aspect, I don't think it's going to serve any useful purpose. So I'm proposing that we add and training. Director General for Legal Education and Training.
Yes, honourable members, he is speaking from clause 1 of the bill. So I intend to put a question. As many as are in favor of the proposed amendment by Dr. Kabiru say aye. Those against say no. Honourable members, the ayes have it. The amendment as proposed by Dr. Kabiru is ordered to stand part of the bill. So I'll put a question on the entire clause 11. As many as are in favor of clause 11 standing part of the bill say aye. Those against say no. The ayes have it. Clause 11 is ordered to stand part of the bill. Now let's proceed to clause 12, which is amendment advertised as XIII integrated. Yes?
Mr. Speaker, with the greatest respect, I think that there is a bill that is laid before this House, and that is what we are working with. It's because of this bill that we have proposed amendments in the order paper. We cannot use the order paper and use the guide that the winnowing committee has given us. That is only a guide. So let us go by the numbering in the law as filed in this House, together with the order paper, and then we'll be on all fours.
Mr. Speaker, there's no disagreement here. That is why the Speaker asked the Chairman to move pursuant or to move item XII. He's not saying you should move 11 in the incorporated bill. He should move XII. But it is to facilitate understanding by members. It's to facilitate understanding by members. That we say that anytime the Chairman moves the amendments here, don't focus on this one. Go to the incorporated document. It makes easy understanding. Do you get it? So I don't want you to labor under some impression that we are working with. It is the amendment that is taking place is focusing on the incorporated document. No.
You see, Honourable Majority Leader, let me explain it to the understanding of Honourable Animedo. We have a bill introduced. There were several amendments referred to the winnowing committee, and the winnowing committee is coming out of this. So once I ask the Chairman to move amendment in XIII, because I ask the members to propose, if any, amendments as captured by the winnowing committee, which is the same as the advertised amendment, it is easier when I refer the members to the provision of that amendment as it is in what is captured by the winnowing committee, which makes it so easy. Because if I don't do that, they will be looking at the old one and be providing an amendment to what the winnowing committee has not worked on. But now the amendment is on the amendment as proposed by the winnowing committee. So it makes it so easy. So the amendment that chairman is going to carry out is as in the winnowing committee's bill, clause 12. So if members now want to propose amendment, then they will be proposing the amendment to clause 12, which makes it so easy for members. Yes. Yes, clause 12.
Yes, clause 12.
Chairman of the committee should move before.
Okay.
Yes, chairman of the committee.
Mr. Speaker, I move the amendment in XIII as captured by winnowing committee as clause 12.
It is for the consideration of the House. Yes, Honorable Kingsley Nyako.
Mr. Speaker, so clause 12, subclause 2G, conduct regular inspections of accredited institutions to ensure the promotion and maintenance of quality assurance standards and practices in legal education, because we have quality assurance, we have the standards, and we have the practices. The practices help us to achieve the standards. So we cannot have the standards alone. That's why I'm proposing that it should be conduct regular inspection of accredited institutions to ensure the promotion and maintenance of quality assurance standards and practices in legal education. I so move.
So you are moving that after the second line, you insert promotion and.
So after ensure we insert promotion and maintenance of quality assurance standards, then after standards and practices in legal education.
So your first amendment on promotion is correct. But here, quality assurance standard, do you promote it? Or you just maintain it?
Quality assurance, yeah, because, Mr. Speaker, we promote quality assurance standards. We promote them. Every institution has to promote quality assurance standards. You set the standards, you promote it, and you also have practices that will help you to achieve them. I thought
you set the standard and maintain the standard that you set.
But we need to promote standards in institutions. You don't only set them.
So, Honorable Kisinyako, how are you going to inspect the promotion? Because if you read this law, it says conduct regular inspection of accredited institution to ensure the maintenance of quality assurance standard in legal education. Because the standard has already been set, and you are going to carry out inspection to ensure the maintenance of the standard that you have set.
You have set the standard.
So, in the circumstances, because of the words used here, inspection of the standard that you have set, how will promotion comes in?
Mr. Speaker, the idea is that you set standards, but standards are supposed to be promoted. Standards are supposed to be promoted, and compliance must also be enforced.
You see, that is why we accepted your amendment earlier. But here, you are going to conduct regular inspection. The word is that you are going there to conduct inspection. And in the process of conducting inspection, you ensure maintenance of the standard that you have set. So in the process of conducting inspection, how are you going to promote?
Mr. Speaker, I use that one, but I suggest that we also insert quality assurance practices, because from where I used to work, if you have the standards, there should be a process that will help you to achieve the standards. The standards alone cannot help you to achieve the results. That is why we have quality assurance practices. So I'm suggesting that if I drop the promotion, then it should be conduct regular inspections of accredited institutions to ensure the maintenance of quality assurance standards and practices in legal education.
So, honourable members, the proposal is that after standards, introduce practices in line 2. So the new rendition will be conduct regular inspection of accredited institutions to ensure the maintenance of quality assurance standard and practices in legal education. Honourable members, I put a question. As many as are in favor of the proposed amendment by Dr. Kingsley Nyarko, say aye. Those against say no. The ayes have it. The proposed amendment to clause 12G, 2G is ordered to stand part of the bill. Yes?
Mr. Speaker.
He's still on his feet.
Oh, okay.
With respect, on paragraph H, I suggest or I request, instead of officials, we insert rather staff, so that we have organized training programs and professional development initiatives for law lecturers and other staff and stakeholders involved in legal education, instead of having officials.
The members of the governing body, are they staff?
Mr. Speaker, I think you are right. I yield to you. My last one on this is paragraph N. Ensure the maintenance of financial records and accounts of the council in accordance with applicable laws. I'm thinking that if it is possible, we look at ensure the preparation of financial records and accounts of the council in accordance with applicable laws. Thank you.
No, this one is talking about the maintenance of the accounts. Maintenance of the financial records and accounts.
That's why I saw the maintenance of financial record, but I'm thinking that preparation of the records and accounts can also be done according to applicable laws. Preparation
by
of the accounts
by the Director General.
But
is it the Director General who is to prepare the accounts?
But if even
the account is it for the Director General?
The accounts is prepared by the Finance Director, but in the name of the Director General.
And the Director General is for what? Legal.
Because we normally, for instance, let's bring it this way. We look at the accounts prepared by the institutions. So whatever account that is prepared is not by the Director General, but it's by the institution. Do you understand? That is the context in which we look at the preparation of the accounts. But this one, we are talking about the functions of the Director General.
Mr. Speaker, I agree with you, but if you look at the preceding paragraph, per your logic, then preparation and submission to the board for approval for approval, so there's even a mistake with that. Prepare and submit to the board for approval the annual budgets, strategic plans, and reports of the council. Per your logic, then the Director General doesn't have maybe any locus dealing with the budget.
Yes, because you see, the records and accounts are different. When you prepare the budget for consideration of the board, and the board has so considered it, it then becomes the document of the board. Do you agree with me? Once the board has approved it, it becomes a document of the institution.
Mr. Speaker, I wish to withdraw my proposed amendment. I'm okay, thank you.
Very well.
Yeah.
Yes. Honorable John Darko.
Yes, Speaker, thank you. My earlier proposal had to do with L, which mandates the Director General to evaluate foreign legal qualifications for equivalence and facilitate reciprocal arrangement with institutions in analogous jurisdictions. Mr. Speaker, my proposal was that this particular function is moved to the functions of the council, because what we are doing is that we're giving one person the power to evaluate foreign legal qualifications. I suggest that that function is given to the Council of Legal Education, and that's my proposal.
Yes, Majority Leader.
I do agree that the Director for Legal Education can evaluate foreign legal qualifications for equivalences, but he cannot facilitate reciprocal arrangements. That's not really a power that the Director for Legal Education should have. And I don't know if even the council alone can have that power. I believe this is a matter that falls within the remit of the commission, GTEC. So I think we should limit it to the Director General making recommendations to the council, but not the one directly making the reciprocal arrangements. Because reciprocal arrangements, does that mean arrangement for both sides to recognize the degrees of either side? If you say reciprocal, it implies that the Director General of Legal Education on his own can arrange and evaluate equivalencies and then indicate that both sides should recognize the equivalencies that he has, evaluated. But I think that he should not have the power to be the one to determine the recognition of the equivalences. It goes beyond him, either the council or the GTEC. Yeah, so I agree with him. I'm agreeing with him. But he's saying we should send the entire function. And I'm saying that there are two functions there. There's a function of evaluation of the equivalences. That we can preserve. But making the reciprocal arrangements, I'm saying, should not be within the preserve of the Director General. But he can do the evaluations all right. But he has to make a recommendation to a higher body, which is the Council, for approval of the equivalences. The Minister for Justice is here.
Yes, Attorney General and Minister of Justice.
Yes, Right Honorable Speaker, I think I agree with the Majority Leader. Because if you look at Clause 3G, the same function is granted to the Council, basically. Because it says to evaluate courses of study provided by accredited universities, now institutions, to accord with appropriate recognition of legal qualifications obtained in institutions in other common law jurisdictions with analogous legal systems as Ghana for purposes of admission to the bar.
So
that
is
is
it the case that we should delete the entire L because it's already in clause 3?
It's the job of evaluation has been granted to the council. So I think we should delete L.
So, Honourable Member, can you move the appropriate amendment and let me put a question?
Mr. Speaker, I therefore move that clause L of clause 12L is deleted.
Honourable members, the proposal is to delete clause 12L. I'll put a question. As many as are in favor of clause 12L say aye. Those against say no. The ayes have it. Clause 12L, as proposed by Honourable John Dako, is ordered to be deleted out of the bill. Any further proposal to clause 12? I'll put a question. As many as are in favor of clause 12 standing part of the bill say aye. Those against say no. The ayes have it. Clause 12 is ordered to stand part of the bill. Clause 13.
Appointment of registrar.
Yes, Chairman of the committee.
Mr. Speaker, I move the amendment in. No. Mr. Speaker.
Honourable members, clause 13 is the original clause 11, and there is no advertised amendment. Yes.
Yeah, Mr. Speaker, I propose that the president is removed and replaced with council, such that the new rendition will read that council shall appoint a registrar for the council, or will appoint registrar. Will appoint registrar for the council. Mr. Speaker, I'm saying this because I'm looking at the appointment of a registrar of an institution. Why should that be given to the president? The president has a lot of things. In fact, it might be better things to deal with than to concern himself with appointments of registrars of institutions. I have served on councils university councils where the council has always advertised and appointed registrars for the institution. And we've never had a situation where even the vice chancellor is involved, let alone the president. Mr. Speaker, if you look at the fact that even the functions of the registrar in clause 14, his first responsibility is that he's answerable to the Director General. And this person is going to be appointed by the president. I believe that if we make the council appoint the registrar, it will be in order instead of asking the president to come all the way down to appoint registrars. So I so move.
What does Article 195 say? Yes.
Yeah, Mr. Speaker,
I just asked a question. Article 195. What does it say?
Mr. Speaker, maybe let me assist the honourable member for Swami.
Very well. They want to assist you.
Yes, I do want to assist him. I think he has a legitimate point. It was an oversight on our part because if you look at Article 195(3), it says the power to appoint persons to hold or act in an office in a body of higher education, research or professional training shall vest in the council or other governing body of that institution or body. So I think that he's right. We should, in the case of the registrar, we should, it should be the council appointing it.
I ask, what does Article 195 says? Because I know the solution to the problem is provided for in Article 195.
You want me to react?
No, I was expecting you to do what he said.
Yes, but Mr.
In moving your amendment and in giving the justification, you understand? He has given the justification for your amendment and everybody will agree with you. That's why I'm asking you, what does Article 195 says? Because in matters like this, it should not be the president who should be appointing. But you did not support it with the provision. That's why I'm asking, what does Article 195 say? Who clarifies the situation?
Mr. Speaker, I think that my point has been supported by the Attorney General.
Yes.
And it's very clear that the
And you realize that use Article 195.3,
yes, the power
which
to
makes it
appoint,
very
the
clear.
power to appoint registrars shouldn't lie in the hands of the
into tertiary
Yes.
institutions lies with the council rather than, because that's why if you look at all the university bills that we have created, the appointment of the registrar is not exclusive preserve of the president under Article 195 because of 195.3.
So my amendment stands.
Yes. Honourable members, propose the amendment and let's move on. Yes.
That the council shall appoint, in accordance with Article 195, appoint the registrar for the council.
Yes, AG, what do you say?
Mr. Speaker, if it is in accordance with Article 195.3 of the Constitution, appoint a registrar of the council. That should be fine.
So the new rendition is the council shall, in accordance with Article 195.3 of the Constitution, appoint the registrar of the council. I'll put a question. As many as are in favor of the new rendition, say aye. Those against, say no. The ayes have it. Clause 13.1 in the Unumi Committee, as amended, is ordered to stand part of the bill. Any further proposed amendment to clause 13? I'll put a question on the entire clause. As many as are in favor of clause 13 standing part of the bill, say aye. As many as are in favor of clause 13 standing part of the bill, say aye. Aye. Those against, say no. The ayes have it. Clause 13 as amended is ordered to stand part of the bill. Clause 14.
Functions of the registrar.
Chairman of the committee.
Mr. Speaker, I move the amendment in XIV as captured by the Unumi Committee as clause 14.
Honourable members, XIV is clause 12 on the original bill, and that is clause 14 in the Unumi Committee. The work done by the Unumi Committee brings it up to clause 14. So please, let's consider the work of the Unumi Committee. So it is for the consideration of the House. That's the A. The proposal is to delete the entire clause A. So, honourable members, the proposal is that original A be deleted. Yes, Honourable Dr. Kabiru.
Yeah, Mr. Speaker, instead of deleting it, I would rather propose we amend it to replacing the Director General to the council with the council. So that the new rendition will be the registrar is answerable to the council in the performance of his or in the performance of function as a registrar.
Well, that is not the original A.
Okay.
So, to get the impulse, we need to move the amendment in XIV, XV, XVI together, so that it will bring you to the clause 14 as it is in the Winnowing Committee document. Yes. You see, the original A
Mr. Speaker,
states that the registrar is responsible for day-to-day administration, which is a function given to the Director General. That is the proposal for it to be deleted. You understand?
I get it.
So, in the new document before us, that has been deleted. So if members are going to propose an amendment based on what is now before us, then we must move clause 12 in its entirety. So, Chairman of the committee, move clause 12 in its entirety.
Very well, Mr. Speaker. I move the amendment in XIV, XV, XVI as captured by the Winnowing Committee as clause 14.
And they are all in page 9 of today's order paper. Honourable members, it is for your consideration. So now we can propose the amendment on the strength of the functions of the registrar as in clause 14.
Mr. Speaker, I probably would first ask the AG to, and maybe the chairman to explain why, because the proposed amendment that I am seeking to do was actually considered as win-win and rejected, because the original version was having the amendment that I'm proposing. The original version was to the effect that the registrar shall be answerable to the board, but it was deleted and replaced with that of the Director General. So if I get the sense of the...
It is here as A.
I get it, Mr. Speaker. I'm just saying that if I get the sense why they deleted the board and replaced him with the Director General, probably my amendment will be obtuse. So I'm just taking from the chairman or the AG.
But if the Director General is answerable to the day-to-day administration of legal education, and then the registrar would bypass the Director General and report directly to the board, why is he a Director General?
Mr. Speaker, I get the difficulty that may pose, and I agree that it could stand because in the...
You see, in the original bill, there was no Director General. The Director General is a new insertion. So certain functions were given to the registrar, because there was no Director General. But now that we have a Director General, some functions are given to the Director General, which can no longer be a function of the registrar. Other than that, it will be duplication of functions.
Yes, Speaker, I get it. So I agree that maybe we should also look at, though it's not similar, but the University Council, the registrar for the university is answerable to the Vice Chancellor. Is that the case? If that's the case,
then I'm sure we are moving closer. But if the registrar of the university is answerable to the governing board of the university,
how can you have a vice chancellor of a university, but the registrar would rather be answerable to the university council?
Mr. Speaker, I yield then. Then that's just the harmony, the symphony of that particular arrangement that I wanted to just be sure. So if that's the arrangement there, then I abandon my amendment.
Yes, but if it is otherwise, it will not augur well. You are there as the vice chancellor of the university, and before you realize, your registrar is reporting to the university council. That will be disorderly. Any further proposal? Yes.
Mr. Speaker, thank you very much. I think the confusion we are having here is because of the issue we could not clear as far as the Director General of the Council was concerned. Now we are saying is the registrar, which here happens to be reporting to the Director General of the Legal Education and Training, which I had proposed because we have defined Legal Education and Training Council. And now we are saying that we are having a registrar of the council and we are having staff to be appointed of the council, but the registrar, the Director General, is not the Director General of the council, but we are rather giving a different entity. That is why I believe we've already passed that and we've lost that. So in that case, we have to have some kind of consistency.
Well, I don't see any confusion here. It's just, I maintain that is just the nomenclature.
Yeah, the nomenclature. So the council, here we have defined the council at the interpretations clause as the Council for Legal Education and Training.
Yes.
For which reason we are seeking to just cancel for the registrar and we are seeking to cancel for the other staff to be appointed in the amendment.
Yes.
So
I understand the point that you are making.
Yes.
You are still insisting that it should be called the Director General of the Council.
No, I've lost
not Director General of Legal Education.
Yes, so if that, because now we are dealing with two entities
By this particular bill, we all know that the Director General of the Council is the Director General of Legal Education. Yes.
Well, Mr. Speaker, there's nowhere that we say the title of the registrar is Registrar of Council. Nowhere. Nowhere. If you look at the heading says appointment of registrar. The title is not Registrar of Council. It's not. So the same way, Director General of Legal Education is a brand. So we prefer that the person is called Director General of Legal Education, not Director General of Legal Education of the Council. The same way that the registrar is registrar, not registrar of the council. In the clause following, in the clause appointing the registrar, it says the council, in accordance with Article 195 of the Constitution, appoints we amended it, but we'll have to go back to that later on, even though we've gone past that, because the Article 195(3) is talking about universities, tertiary educational institutions. What we are establishing is not a university, it's not a tertiary education institution, it is a regulator. So once it is a regulator, it doesn't come under Article 195(3). So we'll have to revisit that issue, either second consideration or at a later stage. So
yes, but let's look at 1953. Yeah. The power to appoint persons to hold or act in an office or a body of higher education, research, or professional training shall vest in the council or other governing body of the institutions or body.
Well, so that is it. You can have a higher body of education conducting research. You can have a higher body of education involving professional training, but you must establish that it is a body of higher education. It must be a body of higher education, which either conducts research or professional training. But, Mr. Speaker, I think we can leave that. We can live with that. Even though it is a regulator, it is not, let's say, the bill is not establishing a university.
I see your argument.
Yes, the bill is not establishing a university. The bill is not, even though there's a point at which we are proposing that we incorporate clauses establishing the Ghana School of Law. If we get to that point, then I think we'll be caught by this clause. We'll be caught squarely by 1953, because we are proposing clause 77.
Yes. There is established by this Act the Ghana School of Law as a directorate of the Council. Functions of the Ghana School of Law.
Then in that case, we are squarely caught.
This thing is to offer courses, including remedial courses for a person who wishes to sit or resit the National Bar Examination. Yeah, so do I put a question? I'll put a question on clause 12 as amended, and now clause 14. I'm putting the question on the original clause 12 as worked on by the Unomi Committee of Parliament to now be clause 14. Those in favor say aye. Those against say no. The ayes have it. The clause is accordingly ordered to stand part of the bill. Clause 13, now clause 15.
Appointment of other staff of the council.
Chairman of the committee.
Mr. Speaker, there is no advertised amendment.
Well, it is for the consideration of the House.
Mr. Speaker, I believe my earlier amendment in clause 13 is also relevant here, that the president should be removed so that we put the council there and then add subclause 3 to 195 so that the new rendition shall read, the council shall in accordance with Article 1953 of the Constitution appoint other staff of the council that are necessary for the efficient and effective performance of the functions of the council.
It is for the consideration of the House. This is consequential. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The clause is ordered to stand part of the bill. Any further proposal? In the absence of any further proposal, I'll put a question. As many as are in favor of clause 13, now clause 15, say aye. Those against say no. The ayes have it. The clause is ordered to stand part of the bill. Clause 14, which is now clause 16.
Internal Audit Unit.
All members, any proposed amendment to clause 16 dealing with internal audit unit?
Mr. Speaker, there is no advertised amendment.
It is for the consideration of our members. Any proposed amendment? Honourable members, in the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 16, the original clause 14, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 16, original clause 14 is ordered to stand part of the bill. Clause 17, original clause 15.
Funds of the Council.
Chairman of the committee.
Mr. Speaker, I move clause, I think it's XVII, the amendment, proposed amendment captured in XVII at page 9 of the order paper as captured by the Winnow Committee as clause 17.
Honourable members, the proposal here is to add loans. And that is, the loans will become D before donations, gifts, and grants. It is for the consideration of the House. Yes. Yes.
Thank you. I have a suggestion that the council should not accept gifts of donations, and if they are only going to
let me deal with the proposed amendment and the reference to have loans. Those in favor say aye.
Okay.
Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, on entire clause 15.
Yes.
17th in the work document. Yes.
Yes, I have a suggestion that the council should not be taking loans or donations, but since they will be giving verdicts. And if they have to do that, then there should be a provision that will indicate that any member with special interest should not be allowed to give donation or compromise the council with their decisions. So I believe with that one, either we insert a provision to indicate clearly that under no circumstance should a gift or donation be accepted from an interested
so
party.
Being a former member, if I have decided to donate whatever small I have to legal education, if the law precludes them, how do they take that?
There should be a provision that indicates that the interest, any member or person or body that whose interests are likely to be directly affected by the regulation, licenses, or disciplinary or adjudicatory functions of the council. Such shall not accept any gift or donation from that person. If you are a former member, I don't think you will share that interest. But if you have a case or you have an interest then once you give out the gift, you'll be luring them into.
What is the nature of the interest we are talking about?
We are talking about the interest. Maybe it's an issue of regulatory licenses or disciplinary action that should be taken against you.
Well, let me hear Honorable Nanyimedu entry on this.
Okay. Okay.
Right, Mr. Speaker, I think that my deputy leader has in mind that in as much as we want to enrich the legal education, she would want us to work against the situation where people may influence the system. But here we are talking about the whole council. So an individual or institution cannot give a gift and we say that it would have influenced the entire council. If it is about the Director General receiving grants or loans or gifts or donations, that's a different thing. Then we can bring these safe clauses to cater it. But the way it is, I think it is nice, and we cannot take gifts and donations from it. Somebody may even decide that in his entire will, he's giving everything he has
towards
to
legal
the council,
education.
and that should be allowed.
Yes.
Right.
So, Deputy Leader, will you drop the proposed amendment?
No, I still believe that I'm not looking at a situation where a former member is making a donation. I'm looking at where the whole council will be compromised through a particular donation that is being made. It will be an influence.
So, let's say University of Ghana is an interested party. University of Ghana is an interested party. World Bank has donated fresh law books to University of Ghana, and the University of Ghana cannot give this book to the council towards legal education. Because it's an interested party, they will be accredited to run the LLB.
I'm looking at this rendition that the council shall not accept any gift of donation that compromises or is reasonably perceived to compromise in independence, impartiality.
Who determines the reasonability and impartiality of it?
Obviously, you always look at the situation, the condition at that point in time.
So who makes that determination?
Pardon?
Who makes that determination? Can I go to court that the World Bank has donated towards legal education and that the donation is impartial?
If I have knowledge of your interest, I think I can actually make that application.
Well, law is a communicative action, and the communication must be clear. Law must be certain. It must not be ambiguous. At the point of making the law, when it will create an interpretational problem, I think we should be avoided. Yes?
I want to look at it from this angle, and maybe if we still are not aligned, then we can look. So what we are trying to look at is to say that funds of the council include A, monies approved by Parliament, B, internally generated funds, C, returns on investment, and D, donations, gifts, and grants, provided that the council shall not accept donations or grants from any person or body whose interests are likely to be directly affected by the regulatory, licensing, disciplinary, or adjudicatory functions of the council.
You should be telling me how that determination is going to be made.
Speaker,
That's why I'm saying that law is a communicative action.
Yes, Speaker.
It must be clear, it must be certain, it must avoid element of ambiguity.
Speaker, that's the point I'm trying to make. I understand that with this rendition, we can all work on it and make it clearer. But I am thinking that the moment we leave donations and gifts, and it's a council that is supposed to govern.
Yes, because we are not talking about individuals here.
Yes.
We are talking about the whole institution.
Which is clear. Which is clear. But Speaker, you know that the whole institution definitely will have somebody who is heading the institution.
No, you see, if you go to give something to the person who is heading the institution, that's a different ball game. But if you donate to the institution, like somebody donating to Parliament of Ghana, that donation is not to Speaker.
Speaker,
it's not to the Clerk of Parliament. So the Clerk of Parliament going to receive the donation on behalf of entire Parliament. It's not personal to him.
Yes, but Speaker, you also know that a donation can be made to the Clerk of Parliament. That would influence his decision on the council.
Yes, but that one is a donation being made to the clerk.
Yes,
but not to Parliament as an institution.
Speaker, so what I'm saying is that if you are giving to the institution, which is fair, that institution would...
My brother, even the judiciary, they receive donation. Ghana Police, they receive donation. The military, they receive donation. National Insurance Commission, a regulator, they receive donation. So institutional donations are different from individual donations. You see, so you, Jerry Ahmed, can be influenced in your decision making by something being given to you. You understand? But everything is given to the entire minority caucus. How would it influence the single individual of the caucus?
Thank you, Mr. Speaker. I withdraw
Very
my
well.
application. Thank you.
I'll put a question on the entire clause. As many as are in favor of the original clause 15? Yes?
Thank you very much, Mr. Speaker. My proposal is in reference to the current rendition that was done for the Ghana Scholarship Authority Act. So I'm proposing for E, 17E, to delete the end after gifts and state that donation, gifts, grants, and any other voluntary contribution made to the council in line with what was done with the Scholarship Act.
New rendition.
So the new rendition will be donations, gifts, grants, and any other voluntary contribution made to the council.
Well, donation, gifts, and grant, which one is not voluntary? Which one is not voluntary? Yes?
Mr. Speaker, I remember during the discussion on the Gold Board Act, which he's referencing, and it's an act of this Parliament.
Are you referencing Gold Board or scholarship?
Exactly so.
Which one are you referencing?
The Scholarship Secretariat, the Scholarship Act, Mr. Speaker, the scholarship.
But you are saying Gold Board.
Yeah, the scholarship, Mr. Speaker. And we were very clear that they could be gifts, even though gifts could be voluntary, but there are certain things that cannot be categorized as gift per se, and they are not donations also. They are given, for instance, Mr. Speaker, we decide that the money for the deceased at Bank of Ghana, part of it should be given to the council. You can't term it as gifts per se.
The money what?
For instance, we have money that according to the Bank of Ghana Act, if a person is deceased and those monies cannot be traced to the next of kin or the person supposed to inherit them, the next of kin of that particular deceased person, those monies are brought to central checks.
And you say it's not a gift, donation, or grant?
I say it may not fit in as gifts, donations, or grant.
Then
and
what
that
is
was
it?
the reason why we made that particular law, unless, of course,
What is it?
I'm saying that was the reason why we said any
Yeah, but
other,
if it is not a gift, grant, or donation, what is it?
that's the reason why we say other voluntary contribution. Mr. Speaker, the name other voluntary contribution tells you that it doesn't fit into this particular category, unless, of course,
Well, for me, I doubt if that is the rendition they agreed upon, but now that we are doing this particular law, by the application of the principles of ejus dem generis, if you talk about donations, gifts, and grants, any other that falls within this particular category is captured. Because these are all voluntary in nature. There is none that is compulsory. So I'll put a question. As many as are in favor of original clause 15, now 17, say aye. Those against say no. The ayes have it. The clause is ordered to stand part of the bill. Then we move to clause 16, which is now 18.
Bank accounts of the council.
Chairman of the committee.
Mr. Speaker, there are no advertised amendments.
It is for the consideration of the House. I think this is a standard provision. I'll put a question. As many as are in favor of clause 16, now 18, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 16, now 18, is ordered to stand part of the bill. Clause 19.
Borrowing powers.
Chairman of the committee.
Mr. Speaker, I move the amendment in XVIII. It's a new clause at page 9 and 10 of the order paper and captured as 19 in the bill as presented by the Winnowing Committee.
Honourable members, it is for your consideration. Any proposed amendment? I think this is a standard provision. I'll put a question. As many as are in favor of 19, say aye. Aye. Those against say no. The ayes have it. The clause is accordingly ordered to stand part of the bill. 20.
Accounts are noted.
Chairman of the committee.
Mr. Speaker, there are no advertised amendments.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of the clause standing part of the bill, say aye. Aye. Those against say no. The ayes have it. Clause 20 is ordered to stand part of the bill. Clause 21.
Annual reports and other reports.
Chairman of the committee. Yes.
Speaker, you know that this morning you said clearly that, in fact this afternoon, that anytime we go to conclave, the kind of decisions we make, we should try and ensure that they are binding. Speaker, one of the things we wanted to do today was to look at this up to at least clause 20, and also consider two statements, one of which is World Radio Day, which is today. And we thought that because it's today, you would respectfully give us the opportunity to take that statement as well.
Yes.
Speaker, besides that,
I agree with you, but you see, from 21, you are going to another sectional note, that is accreditation of universities to offer or provide law practice and training. And the new rendition will be accreditation of institutions to offer or provide law practice and training. So I believe we can deal with 21 and then call it a day, so that when we come next time, we are starting from 22, which is another sectional note. Chairman of the committee, any proposed amendment to 21?
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. It's dealing with annual report and other reports. The question is, as many as are in favor of the clause standing part of the bill, say aye. Those against say no. It is accordingly ordered to stand part of the bill. Yes, Majority Leader.
Mr. Speaker, initially we had planned that today we would take a statement relating to the passing of our colleague, Honorable Murtala, Dr. Murtala. You know, during the during the event following the crash, a lot of statements were made in the chamber. And during that time, we eulogized him and spoke extensively about him, but we did not make a specific statement that focuses on he as a person. So we noticed that omission on our part as a House. So we have a statement that we wanted to take today, but given how late it is, we will rather take that tomorrow. And so, Mr. Speaker, I will leave the matter in your hands. We've done more than 5 hours, so we're entirely in your hands.
Honourable members, are we taking the statement? Honourable members, we have come to the end of consideration stage for today. Honourable members, what is the pleasure of the House?
Mr. Speaker, you can hear my people asking for the second shift, but you've done so well. I've been sat in for, Mr. Speaker, it's about 7 hours now. And not for you to even have water and even go and...
Honourable Nyimeru, don't cry for me.
He has been crying for you, Mr. Speaker, he has been crying. Mr. Speaker, is it respectfully your pleasure that we have the statements tomorrow? Although the World Radio Day is today, and since the leader has requested that...
So I want to abide by the pleasure of the House.
Mr. Speaker, we are in your hands. We would have waited for the third shift, but we are hoping to do the 133.
Well, once we are talking about 24-hour economy and I'm prepared to work, let's take the statements.
Mr. Speaker, it's okay. The 24-hour economy is 133. It's not 113. Mr. Speaker, it's 133. So we are waiting for the second.
If the same managing director wants to be at post for 24 hours for the members to run shifts, it doesn't offend the...
No, Mr. Speaker, it offends the labor laws. It offends the labor laws.
It doesn't offend the bill that we have passed. Majority Leader, the proposal is to have the House adjourned. Is it a proposal to have the House adjourned? Very well. Honourable members, once we've done beyond 5 hours, power to adjourn is in the hands of the Speaker. Accordingly, I'll proceed to adjourn till Friday, 13th February 2026 at 2 o'clock in the afternoon, unless we want to shift it to 12 o'clock. Once we agree on 2 o'clock, the House is adjourned to Friday at 2 o'clock in the afternoon.